DM directed the petitioner to remove the encroachment. My lord, they unnecessarily filed before your lordship. Your lordship dismissed the writ petition to directed them to go before the appellate authority. They filed the appellate authority, didn't get any order. My lord, now the process of removal started. They again filed before your lordship, though there is any scope of get relief. My lord, unnecessary they have filed to delay the removal proceedings. My lord,
You are the respondent in this matter.
in this matter, I am respondent. My lord.
Have you put the other side on notice?
My lord, I have given notice through WhatsApp since he is not getting.
Put the other side on notice and come.
My lord, may I be permitted to mention?
Since you are the respondent, inform the other side.
My lord, I shall inform to them. Over.
After that, mention.
My lord, kindly take it any day. I shall.
Please mention upon notice to the other side. I will not pass it on.
Grateful.
To mention one application for extension of interim order. My lord, may I be permitted to mention item number 82? What happened, my lord? PWD, today is the demolition date. Today I have already served the notice. Today is the demolition date. But yesterday my junior mentioned the matter. This is item number 82. Your lordship.
Notice where it says that today is the demolition day.
My lord, that is in the represent notice.
Copy of the notice.
No, this is already.
Section 1 in all probability.
My lord, I'm giving the notice.
Please show me a copy of the notice.
Your lordship, on an extreme upgradation from the monthly list, your lordship. 3 matters are there. This is second round of litigation. And in one case, your lordship, the highways has already come before me for the demolition process. They have said they're paid, but the second round of litigation is pending. All 3 are happening in the monthly list. I want an upgradation in the daily list.
Upgradation from the monthly list, acquisitions matter. 825, 826 of this month.
Give the number. Give the number.
May I mention the contempt matter? The second time I am mentioning, but the file is here. Your lordship kindly direct to appear tomorrow. I'm great.
May be permitted to mention.
File is not lying here. It has to be requisition. They can in to be mentioned contempt application.
May I be permitted to mention one contempt matter of 2022, my lord?
Lord, may I be
It's for inclusion in the list.
May I be permitted to mention for upgradation? It's a hearing matter.
Affidavits are complete.
Complete, my lord.
Give the number.
Upgrade. Application, my lord, and my lord, new motions.
My lord, may I?
What is your urgency, sir? Yes. Give the number. Give the number, please.
My lord, may I be permitted to mention one matter for listing? This matter was heard by Honorable Justice GHOSH Gupta in absence of your lordship. This matter was supposed to be on list on 6th June, but it is not appearing in list, my lord.
My lord, this is the affidavit of service.
I would like to see the copy of the notice where it says that today you'll be evicted. Because it is already in the supplementary list. Yes. I wanted to see the notice by which you will be evicted today.
My lord, that is annexed 3. That is the last.
It's a section 10 proceeding, isn't it?
It is the SP. My lord, this is the. Without giving any opportunity of hearing, my lord. কবে দিয়েছি? Last time.
This is a 10-3 notice.
Yes.
So you'll be heard, evidence will be recorded.
I'm the owner of the land, but I'm not giving any opportunity of hearing. Nothing, no notice has been served.
It will be given, sir. Now, this is a 10-3 notice.
Yes, no notice has been served. I have said that.
You have received this notice?
Yes. Not in my name, my lord. I'm the Hafiza Begum, I am the owner of the land. Your lordship, kindly see the notice date number. I have not been. This is Mr. Mondal that giving the demand justice. So, this notice has been sent to Mr. Sotoji Mondal, advocate.
Please inform the other side, it will be taken up tomorrow.
My lord, give it.
দিদি এটা নিয়ে নিন, এটা কালকে টপে রাখুন। মোশন টপে
Give it.
Yes, call the days list, please.
The way I had finished my argument in November last year. This is that Justice, on basis of Justice Indira Banerjee's judgment, my argument was her leadership in Austin Distributors that you cannot terminate a lease because the construction could not start. So, Lordship, I had finished, but then for some reason or the other, Mr. Dotto's argument has not been completed.
No, started.
He had taken adjournment after I finished to submit. I'm facing a difficulty is a repetition in the other court because our plan renewal, because the plan has also lapsed. That repetition is, I have been able to get it adjourned thrice. Now the court is getting impatient that then you file afresh because the repetition becomes impractical. Because in the meantime, if I can't get my because my sanction plan, it has lapsed in the meantime. 5 years, I need to get it renewed. That renewal repetition is there. Lordship had fixed it on a particular day when it so happened there was no second half. There was the court rose at.
That's right.
Lordship, any day Lordship can.
12th July?
Wait.
And let it be extended till 31st of July.
12th July, Lordship is keeping it at the top. My Lord.
Hearing, yes, fairly at the top.
Lordship, can you put it at- Otherwise, we shall.
Okay, হয়, সকালেই হবে তো।
Heard learned counsels for the parties. Let the
Time
matter
fix
appear
করে-
under the heading
time
of
fix
one
করবে?
hearing
Time fix
on
করে-
12th July
বলে দাও।
2023, fairly at the
ঠিক
top.
করো।
Paragraph, the interim order granted earlier is extended till 31st July or until further orders, comma, whichever is
Your
earlier.
joint request from both of us, if you could, if some time can be fixed, Lordship, then we can both. keep
দিদি কি
on.
ডাকুন তো একটু? 12th July 3:30 তে কোনো হিয়ারিং ম্যাটার ফিক্স করা আছে? একটু দেখে বলুন। Several matters are being fixed at 3:30, so it so happens that 4 matters are at 3:30, so.
Yes.
it's
No, Lordship, whichever day Lordship
That
is,
happened yesterday itself, actually, so I'm
Whichever-
little cautious.
whichever day Lordship is not,
No, 3:30,
I'm.
Hey.
wait-
marked at 3:30. Fairly at the top, marked at 3:30 PM.
So it will be marked as 3:30.
I'm grateful.
My lord, I am for the petitioner.
Which matter?
I am for the,
Second matter?
the matter is relating for restoration.
Have you served the respondents?
Hi.
So what about your, application?
Yes,
They have
my-
not solved the copy of the
No,
application.
my served the
please serve.
হ্যাঁ সবই দেওয়া হচ্ছে
There's a condonation application also, there's a.
পিপিকে দেওয়া হয়েছে আর সবাইকে আমরা রেসপন্ডেন্টদের সবাইকে দেওয়া হয়েছে
In read petition, we appear on behalf of the state. In read petition, thereafter matter is dismissed for default.
You have no copy. We have not received any copy of that. Although they are saying they have served the. I served the.
Because the state was represented.
In
So that
repetition,
means you have a copy, yes.
I have served the
repetition.
copy. The application has not been served. They have. I have served the copy.
In the several,
To all that-
on
to all
several,
that,
days you have
respondents.
appeared. In the writ petition,
In
yes,
repetition,
yes.
I appeared.
I have served the copy to all the
The
respondents.
copy of the application, mother. Application for restoration.
Restoration application,
Yes.
not served.
Served, yes.
Please serve an advance, please give him another copy.
Served. Yeah, check with the- the copy is extra nahi hai, pore diye devo.
It is actually served, but please give him another copy. Let the restoration be allowed.
I have not seen the copy of the application, whether there is a delay or not, I do not.
There is delay and there is a separate application for the delay. Yes, can 2 of 2021. Affidavit of service.
Motion has.
The applicant petitioner prays for condonation of delay in filing the restoration application. Good paragraph, good grounds being shown. The delay is condoned. Paragraph, the restoration delay is condoned. Paragraph, can such and such is disposed of. Not can 1 of 2021. This is an application for restoration of the writ petition by setting aside the order writ petition which was dismissed for default by an order. This is an application for restoration of the writ petition which was dismissed for default by an order passed on 5th August 2021. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on 5th August 2021 is set aside. Paragraph, the writ petition being WPA such and such is restored to its original file and number. Can such and such is disposed of. WPA the order. Are we ready to deal with the writ petition? No, you're not ready. Let the matter appear under the heading Group 1 motion on 19th July. The writ petition.
Item 3.
Sriman, I am for the petitioner. The Lordship's order dated 22nd of September 2022, directed to pay compensation.
Now, my lord.
November hearing was given. After that, they went silent. Yesterday, my lord, they have served a copy of an appeal with a section 5 delay of 258 days. Yesterday, we have been served.
The direction was for payment of compensation.
Payment of compensation. Page 101. Starts at 101. At 105.
Appeal has been filed, it's pending.
Yes, ma'am.
Yesterday, copy served with a delay of 258 days.
Let there be an adjournment for some time.
As your lordship. It is a short period, my lord, since very long time it is pending, my lord. Short period maybe.
Appeal has to be disposed of first, isn't it?
My lord.
Appeal has to be disposed of.
There is no appeal in the eye of law because there is a section 5 also.
5, yes.
Anyway,
Appear before
there-
the appellate forum.
Yes, I shall.
And I think you need to take necessary steps for expeditious disposal of the appeal. So please do that.
My lord. We shall.
Let the contempt remain pending till then.
My lord.
The alleged contemner is personally present before this court. Affidavit and show cause submitted on behalf of the alleged contemner are taken on record. Paragraph, this court is informed that the respondents in the writ petition have preferred an appeal against the order under contempt. Paragraph, in view of the above, let the contempt application appear under the same heading in the monthly list of August 2023.
Lord,
My lord, dispensation.
Lord. Let it appear in the month of July because Lord,
Dispensed with.
let it appear in the month of
An
July.
appeal,
first.
Mr.
Lord,
Gupta. So
if it is
July.
not admitted, Lord, then
Are admitted now?
first day also it might
Necessary
get
steps
dismissed.
for
I shall
the,
take Lord,
appellate
a
forum.
shorter date.
Let it be
August.
August.
August is not too long.
To be disposed of. Prior to that, nothing can be done with the contempt application.
As well.
Next,
August as monthly list.
Deep operation.
Item 4.
My lord, Gotindo Narayan Rai for the petitioner, he has not come yet as he has fixed appointment with his doctor, my lord, if not today only,
so let it be adjourned for some time.
My lord, in this
For only-
matter, it's an
not
for
today, my lord.
compliance, my lord. 3 dates have been given after your lordship's order, last order.
He is the petitioner, he is the applicant.
Yes, my lord. The 3 dates have been given, one more date has been given, your lordship will fix it after that date.
Oh, they are not appearing before?
No, my lord. My lord, next date is 10th July, sorry. My lord, 3 dates were given, 17th May, 31st May, 15 June. Opportunity was given. They did not appear.
Before the authority.
My lord, I am informed by him by my lord mobile, my lord, only
On
Not
prayer of
only
fact,
not today, I am
petition,
praying
the
for
matter
my
is
lord.
adjourned, then let the matter appear under the same heading on 14th July.
14th July, my lord. Great.
Item 5.
This matter, my lord, I am for the contempt. My lord, I pray some time.
I am appearing for the petitioner, my lord.
That is the entire procedure is, my lord, is the another way. my lord.
Kindly consider, my lord.
I see the procedure of the.
One month?
Yes, my lord. My lord, 6 weeks, my lord. As because
No, my lord, 1 month
entire
would be,
proceeding- আরে ভাই এন্টায়ার প্রসিডিং চেঞ্জ করতে হবে যেভাবে লিখেছে ওভাবে লিখলে হবে না my lord is complete the proceding, my lord, but that's for completion is not a is
6 weeks, very good, 6 weeks, come
yes
down.
ma'am.
On
But
prayer
the
of the
affidavit
alleged
of-
contemner, yes,
affidavit of service.
truth affidavit of service. On prayer of the alleged contemner, the matter is adjourned, let the matter appear under the same heading on August 9th.
9th August.
9th. কোথায় যাবেন? Oh, let it be 14th August. Next,
Item 6.
For the petitioner.
My lord, I am on behalf of alleged contempt, I am led by near advocate Amit Kumar.
yes,
My lord, right now.
have you complied with the order?
Yes, my lord,
Yeah, my
we have given them a notice of hearing on 8th, they appeared, they wanted 4 weeks time. Thereafter on 14th, they have given certain other documents. Well, kindly see the contempt application for once, my lord. Contempt of that.
Yes.
Now, kindly see the contempt application for once. Kindly see just 2 pages, my lord. Kindly take, my lord, page 29.
29 of the contempt application?
Yes, my lord.
Yes.
Kindly see, with due respect, I, Taraknath Ghosh, son of Himachandra Ghosh, my lord, as follows, registered deed of LR right
showing clear title, details of drawing and structural stability. And enclosure is 1, 2, 3. Kindly turn over the page, my lord. Kindly see page 31, there is only one document to whom it may concern. Then this question of subject to correction, my lord, the deed in our copy is not there. And also, my lord, the detailed drawing of the building. It's not there in our copy. I don't know, my lord, whether it's there in the my lord's copy or not. Now, these three documents they have to submit. This is an admitted position. Now, on 8, we have called, my lord, subject to my lord's kind consideration, we have affirmed an affidavit. We have called them on 8. Now, on 8, they appeared, and my lord, they took time. Thereafter, my lord, on 14th, kindly see, my lord, page 17.
Of your affidavit?
Yes, my lord.
Page 17, yes.
Yes, page 17, my lord, they appeared. They appeared, my lord, and Tarknath Ghosh, 8, my lord, they appeared, but they did not give any documents. In fact, orally they prayed for certain time. Now, my lord, kindly turn over the page, my lord, that is 14th of June. 14th of June, again they say they have supplying this. Now, so far as the detailed drawing of the building is concerned, even that subject to correction is still not there. Now, this document that they have given, my lord, the registered deed and LR showing right, this needs to be examined and we will come to a conclusion. That's the reason, my lord, we could not comply in details the order, but it's not our fault, my lord. They are not supplying with the documents.
How much more time do you want?
Well, it depends upon, my lord. Kindly see their document. Kindly see, my lord, there are 3 documents.
They have produced the documents.
Even today, detailed drawing of the building showing complete, including height, width. Kindly see, my lord, page 18, which they are showing. 2 is not there. It's, you see, my lord, today, if I have say you have not completed documents, fair enough for the time. So this is the position. They are. So first they did not submit the land records, registered deed. Then after only on 14 they have submitted this, and even so today I have to know, my lord, what they will do. In order.
Let us hear the applicant, yes.
On 8th, we appeared. Authorities asked me to submit the documents further. I further submitted. They also requested to take 1 month time before the court to comply with the order. Kindly adjourn the matter for 1 month.
Have you submitted the details?
All, my lord. Twice, my lord.
No, our instructions is no. In fact, kindly see the court's copy. Even in court's copy also, it's not there.
Where is the detailed drawing showing complete layout?
No, on 14th, I have submitted, my lord. 14th June. In their affidavit, there is no document.
No, in the court also you have said.
In the
First time they submitted before Lord Sir, deed I have not submitted.
in the
That is
contempt
deed.
application also,
Yes.
the deed copy.
Yes,
of
yes,
the
yes,
deed is not
yes,
next.
yes, yes. Kindly see, my lord,
You
page.
say that you have submitted all these documents earlier
Yes.
also.
Kindly,
So where are the
Pa-
copies?
page 32, my lord. Plan is there. In the contempt application. They asked me to submit
32.
further. I have submitted all the documents
Page
further.
32.
Yes, my lord. Plan is there.
This is the detailed plan.
But 32 they have not supplied as a copy. Kindly see. In any case, the
Contempt
deed is not
application.
there.
Contempt application.
The
Contempt
contempt application deed is not there.
deed is
Plan
not there.
Yes, yes.
Let them submit a plan, my lord, because it's enough.
So I give you another month's time.
Yes.
But they should submit this plan, my lord.
Not submit. I have.
No. If not submitted, but this will continue. Let them submit. What's the point? You have supplying me the copy without these documents. This is not right. And why should I say something incorrect before the court of law? You submitted document.
Please find it.
And I have submitted. And I have specifically submitted before Lordship on 14th June. All I have submitted.
14th, I have shown my lord the copy. And I specifically pleaded.
Now, the plan that is annexed to your contempt
Yes,
application is not in the affidavit. Filed
This
today.
is their affidavit.
It's their affidavit, yes.
Yes, but you have not supplied
Yes,
me.
further, my lord, for the
Acha-
second time I have submitted. This is the first one. On 8th June,
Copy of the deed is there. ROR is record of rights is there.
yes,
But the plan is not there. Detailed plan is not there.
I have submitted. I can, today, I can show your lordship, I have submitted.
Please show me
Tomorrow,
the
tomorrow, Monday, I can show.
I'm not understanding, my lord, if they can't submit one.
Since, I mean, if you do not cooperate with each other, this will not
Absolutely.
be possible at all. So please find out, please find out. You may have missed it. Or maybe Mr. Roy is not properly instructed. Please find out.
Yes,
I do not want to get into that.
no, so
I'm
let
giving
them
another
submit
month's time.
and let them submit another copy that will resolve the issue. Let them submit to me the lawyer. It will help, my lord, to expedite the process.
Yes, yes, I will submit.
Yes?
Yes, yes.
So I
Only
give
only
another
plan,
month's
only
time.
plan. Yes.
Deep, may I take my lord's deep, my lord?
Affidavit submitted on behalf of the alleged contemner is taken on record. Paragraph, learned counsel for the alleged contemner seeks a month's accommodation to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on 21st July.
আর প্ল্যানটা একটা দিয়ে দিও না তো এগোবে না।
Please ensure compliance.
Yes,
with the
yes,
law. Next.
I'm for the
Seven.
petitioner, my lord. My lord, my affidavit of service.
Mr. Day, your appeal?
Yes, ma'am.
Complied?
Yes. My lord, I take a, my lord, exception to this. On 16th, my lord, I have received a letter from them, my lord, whereby they say, my lord, that they have called me for hearing at Bhavani Bhavan with a day's notice, my lord. On 14th, they informed me. On 15th, my lord, I was required to be present. And on 16th, my lord, they closed the entire thing, my lord. I could not appear. My lord, kindly consider, my lord, I am an ailing, aged person of around 80 years of age now. My lord, in the scorching heat, my lord, I come from somewhere in South 24 Parganas is very far away, my lord. I could not be there by 5:30. I came, me and my son arrived a little later, my lord. From Bardhaman, my lord, I have to travel all the way to Bhavani Bhavan, my lord. It was not
Could you
possible.
appear before the authority?
No, I could not, my lord, within that time, within a day's notice. And my lord, the points that they have taken, my lord, in that, have I handed over, my lord, a copy of this report, my lord?
Where is the notice issued upon you?
My lord, they must be having, my lord. I only received this through, they have sent me a
This is
scan.
the order, the notice.
This was only served upon me. The notice, my lord, notice I do not have, my lord. It is with my client, my lord. He could not come today, my lord, from Bardhaman. But that was on 14th, my lord. I admit, I only got a day's notice.
Did you inform the authority that you were not able to attend?
No, my lord, I
You
traveled, my
receive
lord.
a notice, you do
I
not
received a
attend.
notice when I reached from Bardhaman, my lord. It was after 5:30. I could not attend that hearing.
Bardhaman is only a little distance from Calcutta.
He, my lord, in that this person, my lord, in the scorching heat, he is suffering
This
from
is no
it.
ground, sir. You could have
No,
sent his
my
representative.
lord, I bowed before, my lord, but
You have
I'm-
received a notice and you have not attended the hearing for whatever reasons. An order has been passed. So this is the order of the court has been complied with.
But my lord, the statements that is made in point number 5, 6, 7, and 8 regarding the joint inspection, on instruction, I'm saying, my lord, it has never taken place. I was
That is a
present there.
separate cause of action. That's a separate cause of action. And the order says joint inspection if necessary. It was not a
My
mandate.
lord's order, my lord's
Yes,
order.
it was not a mandate.
But the order that is being submitted before my lord, over there, they have.
If you are aggrieved by this order, it's a separate cause of action. In the contempt application, I cannot deal with it.
My lord, if one opportunity, one other opportunity of hearing can be given with at least a day's notice, so that I can be present.
This was given to you.
Yes, my lord, my lord, due to the scorching
I
heat, my
don't
lord.
think it will be, Mr. Dey.
Another opportunity of hearing, my lord.
Your lordship will 5, 6, 7, 8, if your lordship will see what is the position and attendance slip at the joint inspection, my lord, that is page 27.
I'm sorry you have to come before the court again. Because the order has been complied with.
Well, at least give me an
You're asking for the
opportunity.
review of this order. This cannot be done in contempt.
But since the affidavit that they have served me today, if I am given an opportunity of taking an exception to
Exception?
this,
Let him come back with an exception.
and my lord, kindly keep it on the same day as on 14th of August. My lord, the other item number 5 was also on
14th of
August.
August. Such a long date.
My lord, both the matters will be together.
No, not necessary. That is for a different reason.
Anyway, my lord, any date, my lord.
Affidavit of service. Affidavit of service and the order passed by the alleged contemner on 16 June 2023, filed by the petitioner, applicant petitioner are taken on record. Affidavit of affidavit of competency.
Should be compliance. my lord.
Compliance report, compliance with the
Affidavit of competency.
My lord, that is the typing mistake. Sorry.
Affidavit of compliance submitted on behalf of the alleged contemner is taken on record. Paragraph, learned counsel for the applicant petitioner seeks to use an exception to the said affidavit. Paragraph, let the matter appear under the same heading on 11 July.
11 June.
Same
Give this.
Item 8.
My lord,
I appear for the petitioner in this matter. Copy of the contempt application as per your lordship direction has already been passed.
Who is appearing for the alleged contemner? You are
I
appearing.
appear for the alleged contemner. Just time I've got the brief.
That is immaterial. But there is a division main direction, specific direction. I am telling your lordship regarding
I
the.
intend to give him some more time because he has just received the brief
Just now.
No,
I have even.
his client has already communicated his views.
of the learned counsel. He is not ready at all today. Come back some other.
His client, SP, has given us a letter indicating that he cannot comply with the order of court.
Let him,
This is a-
let him come back with instructions.
My lord, we are for the
Lord.
applicants in this matter. We have applied for application of addition of parties. Can one
Contempt
and
matter,
can
no one
six.
can.
My lord, I would just like to bring this to this court's attention that it was can 1 was supposed to be fixed to be heard on 27th of April, which is before the contempt was filed to be heard. So I am most respectfully and humbly praying to this court that this be taken up.
Contempt matter, there is no scope, madam. Let the contempt matter be disposed of. Come back after that.
But
The writ is pending.
It is pending.
It is pending.
yes,
Division
yes, my
bench had
lord.
passed it.
I'm requesting that it be taken up at the earliest because
No,
After the contempt matter.
we have made several prayers on several occasions
Yeah.
for
no.
this.
Every video service we kept on
The
record.
writ petition is not being dealt with at all now.
The water body has no demarcation. It is a huge problem, my lord. It is not.
Problem. There is a law. Read the law and then come back. 273 regulation. Read the
Affidavit of
regulation
service.
how it is to be handled.
Amlan, affidavit
No
of
huge
service.
problem.
Paragraph on prayer of the alleged contemner, the
That's a
matter is
drama.
adjourned. Paragraph, let the matter appear under the same heading on 5th July.
5th July, as you lord.
Ensure compliance on the by the next date.
Kindly record that, my lord. Kindly record that.
Affidavit of compliance be submitted on the adjourned date.
Great. Give your
My
blessing.
lord, so far as this is concerned, my lord, this is a huge water body, my lord. In this water body, my lord.
You are
None of the-
aware that that scope of a contempt application is very limited. In the event you have not challenged the original order, you have nothing to say in the contempt application.
My lord, let me come
Contempt
back.
application is only for compliance, nothing else.
Let me come back.
I will not hear anything on merits in this. Next.
Item 10.
In law, I am the Ashish, in my read petition was prayer was made, Ashish.
You served?
No.
Will you serve and come back? The applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 17 July.
Yes.
Item 11.
Yes,
I pay for the national.
yes, Mr. Rao.
Yes. The petitioner before your lordship. Some problem, my lord. It is hot and cold. Throat got
And
choked.
everyone is facing that problem.
Now, my lord, what happened, my lord? The land of the petitioners were acquired. According to us, my lord, this acquisition took place, or the award was declared after 1/1/2015. So, though the award was calculated on the basis of the earlier method, be as it may, I am entitled to get statutory component that is a 100% solution and interest to that effect. Pursuant to which, my lord, a report was filed by the state. My lord has the copy of this report.
Yes, yes.
I am only drawing a lord's attention to page 3, that is the R1, the status report.
Yes.
The detail clause 2 minor you'll find the determination amount payable as compensation as under 3AG1. That is by the competent authority, my lord. That is the date for declaration of the award of act by the competent authority on 2/7/2015. The amount of compensation also made payable to each of the writ petitioners. There is no dispute regarding the same.
Admitted.
Admitted. I also admitted, yes, I have received the copy. Now, my lord, after that, what the report wants to stay, I could not understand because it is not a 24. I did not ask for the lapse. I want that it should be done in accordance with 2030 Act Schedule 1 and Schedule 2. Because this is the act applicable after be as it may. Today, my lord, they can jump over upon me. This is the arbitration was held, but I am not on that also. Whether I am entitled to get statutory component or not. This is now, my lord, redundant. The Honorable Appeals Court have said, yes, Schedule 1, I am entitled to get after 1/1/2015. The judge, so whether, my lord, I am entitled to get that. The prayer, it was currently considered, this was made in that 2018. Now we are 2023. That's why, my lord, if your lordship can consider redetermination of award. My lord, redetermination of award is, my lord, in the essence, my lord, I am praying for the statutory component. My lord can mold the relief into that effect. Because at that point of time, there is dispute regarding the what will be the effect. That's why, my lord.
Component has been allowed by the arbitrator?
No. Statutory component.
Yes.
If your lordship can consider.
So in that case, section 34.
Yes. Page, no, my lord, page 5. The arbitral award is also annexed with the state.
The point that the Right to Fair Compensation Act should be applicable was not taken before the arbitrator. The same advocate who has filed the demand of justice, which is annexed at page 150, has appeared on behalf of the petitioners in the arbitration proceedings.
But it is 2017 this came, and this arbitration was held in my lord since sometime in 2016, and this representation was made in 2017. Because my lord knows very well the notification which was issued, my lord, in the year 2017, giving declaration that it will be effective from 1/1/2000. Even if, my lord, can you consider, even if, my lord, whether there is estoppel, this is regarding the estoppel against the statute, whether it is permissible. I am entitled, the statute give me that right to get 100% solution and the interest.
Subsequently.
Yes. So whether I am entitled to get, it is not any estoppel against the statute. It is a right flows from the component.
The order was passed in 2016.
Yes, Your Lordship. The award was
statute
passed in
allowed it
2016. Yes.
And there is no discussion. My lord will not find a single word regarding discussion of this.
No, there was no scope.
There is no scope at all.
In
Lordship.
2016, there was no scope for submission on this issue.
Lordship, initially the Right to Fair Compensation Act was made applicable by a notification dated 31st December 2014.
Yes.
By which it was said that with effect from 1st January 2015, the Right to Fair Compensation Act shall be made applicable. Now, the clarification which has been made by the Supreme Court is that the date to be taken for determination, that is, as on 31st December 2015, the requiring body has to pay the acquiring body the entire amount. Initially, as per the Pune Municipal Corporation, the interpretation was that the landowners have to be paid the amount, or the amount has to be deposited in their accounts, or it has to be deposited in court. Now the Supreme Court has decided that no, insofar as the compensation is concerned, if the requiring body has deposited the compensation before 31st December 2014, then the new act will not be applicable.
My lord, that's subject to question, my lord, what my learned friend is something that is the application of section 24 in the lapse proceedings. Previously, my lord, your lordship can consider the act itself. There, my lord will find either award declared or compensation paid. There is a dispute between two equal weighing judgment that whether or will be considered to be a disjunctive or and. The 5 judge bank said not only if the payment is made by the requiring body to the disbursing authority, then also section 21, this is a lapse proceedings, and that lapse proceedings does not apply to national because it is a separate statute.
You are only claiming the 100%.
Yes, separate statute. It is not under the land.
So far as this is concerned, the arbitration award has already taken place in 2016. Thereafter, this application has been made in November 2017. Your
What is the remedy? Because
Lordship,
after
let
the
them challenge.
award was passed, this came into force.
Lordship, in so far as the present petition is concerned, first of all, it is filed by 68 petitioners. I do not know whether the court fees will be deposited.
If that state takes the physical.
There is an order of a division bench of this court. that
Sales
the
this is the land losers.
No court fee is required.
Lordship, in so far as the award is concerned, if the award copy has already been, they have admitted in the writ petition that they have received the compensation as per the enhanced award. Your Lordship,
What is the remedy if there is a subsequent development?
this
that
is
is
not a
not covered by-
subsequent development, Your Lordship. Your Lordship, as on the date on which the award has
The
been
award-
passed,
Supreme Court was in 2017.
Lordship, 14 January 2016 is the date of the arbitral award.
Yes.
As on that date, the new act had already been made applicable to acquisitions under the National Highways Act. This point was not raised by the advocates appearing for the landowners before the arbitrator. This has come into effect from 1st January 2015, Your Lordship, and this award has been passed on 14 January
If you
2016.
consider the representation submitted by the.
Lordship, let the representation.
One thing, my lord, may I subject to my lord's, my learned friend's contention.
May be required in this order.
Lordship.
My lord, one thing, if the act statute said, my lord will find, it is the duty of the competent authority to market value and the other component. Now, my lord, can you consider the adjudication of the arbitrator? Because, my lord, it is what is the power of the arbitrator? Because it is a specified act, it is incorporated under the national acts. If your lordship can you consider 3H4. If any dispute, where the amount determined by 3G or arbitrator,
Page 4 is apportionment.
apportionment, no, my lord, the arbitral. The amount determined by the competent authority under subsection 1 of subsection 2 is not acceptable either parties. The amount shall on an application either of the parties determine the arbitrator to appoint by the central government. So this is my lord, the quantum that is 3H 3F5.
3F5.
3F5 is 3G5. 3G5.
PG5 is application before the arbitrator.
Arbitrator, that is only the quantum. So for the this is my lord, once my lord earlier occasion I satisfy your lordship. This is a solicium is the shadow of the original. Is any stage of the proceedings if the court found that he is entitled to get solicium and interest, that is will follow the compensation. It is the duty of the competent. If my learned friend's condition is taken into account, then apart from that will be it is their duty to provide me the same. Because according to them, this is passed in 2014. Then why they did not give it to me? Arbitration, arbitral, my lord, can you consider? This is the solicitation interest. I'm not on market value. What they're trying to submit is market value is recording a variable component which will be adjudicated by the authority where is any adjudication is necessary. But where is the statutory? The solicitation interest as the statutory component. It does not require any adjudication. It flows from the statute itself.
If it has not been adjudicated by the arbitrator.
Even if, my lord, for the sake of argument, assuming I'm on.
Becomes the duty of the arbitrator, he has not done it. Yes? So what is your remedy?
No, my lord, here the arbitrator is not, this is our market value. My lord will find.
You are on merits of the arbitration.
No, I am not on that also. It is come.
It is not that the arbitrator had declared it and the authority has not complied with it. It is not that.
No, my lord, sir.
Earlier submissions, it was that.
No, even if, my lord, I am taking the submission of my learned friend, then also this is a statutory component. Arbitrator will not disclose that whether I am entitled to get statutory component or not.
No,
arbitrator will no. Subject to question, my lord, no. Arbitrator will declare that whether the market value assessed by the authority is correct or not.
That is inclusive of the
it is
solatium.
Grievance with regard to any amount.
Any amount, this is the
Not only
market.
the market value. The amount determined by the competent authority, that includes everything.
That includes
This
solatium
market
and
is
interest.
subject to value the
It includes solatium, etc. Not only the, where is it stated that only the market value can be challenged?
market value, my lord, this is the variable component, which you can
Maybe
adjudication.
Even the statutory component can be challenged before the arbitrator, which you have not done.
There is no occasion on my part because it's 2015. 2016 start.
2016. is the
70,
amount.
28 December
Have you
2017.
have taken recourse to the 2013 Act. The Act was there in vogue.
Yes, but fourth schedule not been included. Subsequently, it was included.
No. Your lordship, if your lordship gives me a day, I'll produce the notification. The notification
I have
is before
annexed.
the date of the end.
I have annexed. What is the notification is there, my lord? Initially, it was by a notification the question cropped up whether by this notification whether the act can be included or not. I have annexed in my application also. (145) P3.
28th August 2015, your lordship, page 145.
This is the Press Information Bureau's report. It is does not affect the, because their point they have taken whether it can be considered to be the amendment of the fourth schedule or not. After that, the opinion was
Prior to this, there was a notification of 31st December 2014 as well.
Page?
That has not
Page.
been annexed. That has not been annexed to the petition.
You had the occasion to mention this before the learned arbitrator, which you have not done.
Absolutely.
Subject to question, my lord, I cannot. I cannot. Subject to question, my lord. This act, fourth schedule amendment came into force with comprehensive guideline in the 28 December 2017. The comprehensive guideline which was followed by the National Highway Authority. Because these were, my lord, though it was filed in 2018, here your lordship will find page 51. Page 51. Therefore, now it is proposed to issue an order under section 13(1). My lord, Gul, 51.
Of your writ petition.
Oh, page 146. My lord, I beg to be corrected.
Page 146.
46. The writ application.
Yes.
My lord will find the fourth schedule, the act have been mentioned after that. Therefore, after that. Therefore, now it is proposed to issue an order under section 113(1) of the said act to extend the provision relating to the determination of compensation to accordance with the first schedule. Resettlement in accordance with the second schedule of the infrastructure amenities accordance with the third schedule shall apply to all cases of land acquisition in a specified fourth schedule of this act. So till, my lord, 28th August 2015, there is no declaration on that aspect.
What is of 2016, your lordship?
So there is no declaration. Declaration comes afterward. And the proceedings initiated, kindly consider that when the proceedings was initiated, if your lordship, but my learned friend is submitting, the proceedings was initiated sometimes on
The order was passed in 2016.
2016. So there is also proposal.
It's only a proposal.
Lordship, this proposal had come into effect. This is one of the proposals. In fact, by the notification of 31st December 2014, it was clarified that the first, second, and third schedule of the Right to Fair Compensation Act shall be utilized for, there were 11 enactments, out of which enactment number 7 was the National Highways Act. Under the Right to Fair Compensation Act, if your lordship sees the fourth schedule, lordship will see that National Highways Act is one of the enactments to which the first, second, and third schedule of the Right to Fair Compensation Act shall be applicable for the purpose of determination of compensation. The cutoff date has been given as 31st of December 2014.
Page 145, last paragraph.
Yes.
This was clarified by the authority. According to the such act, ordinance 24 was promulgated on 31st December 20. Subsequently, the amended ordinance 2015 was promulgated on 3rd April to give continuity of the provision reflected ordinance such and such. was promulgated 30th May 20 to give continuity to the provision reflector ordinance. The replacement bill relating to the reflector amendment ordinance 2015 was referred to the Joint Committee House of Examination and the report and is pending with the committee. As per provision of Article 120 of the Constitution, such and such ordinance shall lapse on 31st August 2015, thereby placing the landowners in a disadvantageous position in denial benefit of the enhanced compensation, rehabilitation, and resettlement to the cases of land acquisition under the 13th Act as specified in Court Schedule Act extended to landowners under the said ordinance. Therefore, since the central government considers it necessary to extend the benefits available to the landowners under the such Act to similarly place landowners whose lands was acquired under the 13th Central Enactments Court Schedule, the central court decided to uniformly apply the beneficial provision of Section 105 of the reflector relating to the determination of compensatory rehabilitation as made applicable in case under the interest of the landowner. Then, my lord, what my learned friend is submitting that the 8 is the National Highway Act, my lord, will find 7. And this is the proposal which is given to the Joint Committee pursuant to the report. So, if my learned friend is submitting the ordinance because it was placed to the Joint Committee, the decision was taken. I only produced the copy for the purpose of that. From here, I came to know subsequently. I appeared with the authority. I am also entitled. Whether the committee have passed or not, that the bill was enacted subsequently in 2017. If my learned friend.
Where is your representation?
Yes.
Lordship, let us come up with an affidavit, your lordship. If you want to file an affidavit in this, the affidavit will place the relevant notifications on record.
My lord, one thing, my lord, I am submitting, my lord. This is the manual guideline of the National Highway Act, which was
This is for the purpose of clarification.
26 February 2018. This
Lordship,
26 February 2018.
Mr. Roy, I think.
The
Mr. Das
relevant
is correct.
notifications are there in this. We will annex in
We
the
can clear
affidavit and
this
we'll bring it
issue once and for all.
on.
Report was filed, my lord. Subsequently, my lord, the National Highway Authority did not let them disclose what is the breakup of compensation.
Third learned counsels for the parties. The matter needs to be heard on affidavits. Paragraph affidavit in opposition to file within 2 weeks. Mr. Das?
2 weeks, your lordship.
2 weeks from date
Multiplication factor
of affidavit in reply, comma, if any comma be filed within a week thereafter. Paragraph, let the matter go out of use for the time being. Please mention upon extension.
First schedule. That is into the 13 Act 2016.
Yes, next.
14 January to my board.
13 Act 2016 তে তোমার যেখানে অর্ডিন্যান্স হচ্ছে 14 জানুয়ারি থেকে আরবিট্রেটরি জেনে গেল, ল্যান্ড অ্যাকুইজিশন ইয়ে জেনে গেল।
Item 12.
Applies.
There will be some limit.
We are for the state, madam.
Malada beg to appear on behalf of the national authority. Mr. Roy, this one? Exception is a time.
No, doesn't mean equal.
No, it will. Yes.
If your lordship can consider.
Have you used the supplementary affidavit?
They have annexed the copy, which just asked by your lordship.
Not required.
They have annexed by the state. Report in the form of affidavit. My lord will kindly consider. Page 6.
কি করে দিয়েছেন? What is your case? What is the
Yes.
matter about? My lord, he's. Sir, bolun. Are you challenging maintenance?
Lordship, if you lordship kindly see the prayer, my lord. His prayer, lordship, to accept the application under section 3G5. My lord, this application is nowhere annexed in this writ petition. Only prayer, my lord, to accept this application.
Yes.
Yes, my lord, can you consider the report?
Yes.
My case is that they have enhanced, they have considered the arbitration is land in question. No adjudication regarding the structure, they have either accepted or did not made. Now, can you consider the report itself? On examination of the case, it appears the petitioner received the compensation amount to such and such determination by the competent authority. My lord, this is relating to, my lord, 3G1. The plot number such and such, against the award serial number such as the value of serial number. On the basis of the petition, arbitration hearing was conducted. This magistrate arbitrator on 17/8/2017. The petitioner already received the arbitral amount and the for the land, but no amount appreciated by the arbiter for compensation structure in arbitration case number such and such. And again, so for the determination of rate of quantum compensation in respect of the structure for plot number such and such. In terms of section 7 of National Highway Act is concerned, section 7 is provided with the scope of fees of service and benefits rendered on national highway. Whereas the petitioner engrafted the design to get relief by taking recourse. The provision of section follows. Under market value, if the damage is sustained by the person interested at the time of taking possession, the damage even is sustained by the person interested at the time of taking possession. If the consequence of the acquisition land in person interested compelled to change it, but instant matter provision 307 determination of structure value is not applicable, as ensuing provision is silent about it. Therefore, claim of the petitioner will get relief under the provision of section 3G7 loses propriety and reasonableness, and the instant petition is liable to be dismissed. So this is the sum and substance regarding that. The land they have done. Now I'll consider my application which they have annexed.
Your application under 3G5 was accepted by the authority?
Yes.
And they have received.
No, no, I'm দেখাচ্ছি তো।
What is
I'll
your
kindly
prayer,
come to.
Mr. Roy?
Yes, Madam, can turn to page 18.
Page 10.
Let me complete after that. You'll make my
Yes,
submission. Page 18.
Of the writ petition
No, no, report. I am relying about their documents.
From the state document.
Yes.
page 18.
Yes. Competent authorities document, my lord. Not state under the competent authority.
Yes.
This is the application which is the arbitrator
Made by the petitioner?
by the petitioner. Where my lord will find award number 686 and 685. Your lord will find
Mr. Roy, what is your prayer?
to accept my application under
It
section
has been accepted and dealt with.
under structure for structure. That is why there is
Fresh cause of action arose, my lord. The fresh cause of action arose.
if my lord kindly consider 2 arbitration award was declared. 2 amount was declared, 2 awardee number. So each respect I am entitled to make an application going by any of the proceedings. Here, my lord, I have filed my award number, serial number 686, 685 relates to land. So in any event, I'm entitled to file an application in respect of the award which was declared.
Where is the copy of the application?
This is the copy of the application.
This is with regard to land.
Yes, because they're not accessed. That's why it is scored through. That is why it is scored through structure. Why, my lord, I'm drawing lordship attention, I'll call it the award list. They have annexed. $578. My lord will kindly turn to page.
Here your request was for redetermination of market value of the land.
That cannot be. That is not permissible.
It is your application. Page
Yes.
19.
Yes, land. I have accepted in my writ application. My lord, can you consider my writ application? Paragraph 12. Ought to have accepted the application for enhancement of the compensation interest of the building and structure of the petitioner, but the respondent authorities with an oblique motive refused to accept the application interest of the enhancement of the compensation, the building and structure. My categorical statement made in my writ application that they have done in respect of the land in question. They did not, no arbitration took place in respect of structure because the authority under, why the authority have done so, my lord, that your lord shall find.
Where is your application with regard to structure? That
because
was
it's
the
a
application which they have not accepted. Please
That-
show me that you have made an application.
It was not accepted. That is my prayer.
What is your application, sir? There has to be an application to be accepted.
This is a copy.
If you have not made it by now.
No,
we
it
have
was
no
there.
choice.
It was there, but it was sent by.
Please show me a copy of the application, Mr. Roy. Otherwise, you have no case.
This is a copy, my lord, which I intend to. But it is not the entire copy. The first page is with me. If your lordship may allow, my lord.
That's why you wanted to come back with a supplementary.
The structure award number, my lord. That's why, my lord, 727.
I'm sorry, this is not legible at all.
May I read out for your lordship? Jocelyn Shorter, why have such an application for arbitration for structure, schedule of land and other relevant particulars? Case number such as Moja Govindapur, structure award number 527. Classification body, total amount of compensation structure is rupees 41,39,092. Because this came up for consideration on the earlier occasion also.
When was it sent? Where are the documents?
Sent, my lord,
You have to substantiate your prayer. Your only prayer is for acceptance of an application which they have not accepted.
yes, my lord, Kali.
Show me that you made an
Yes, my lord.
application. The postal receipt, if you say you've sent it by post,
No, it is not. It is by through hand. They did not accept.
by hand, it cannot be sent by hand to the arbitrator.
Yes, my lord, earlier
Not
the
application.
documents which they have accepted is by personal service, which is annexed also. That is also through personal service.
And lordship in
And
paragraph,
this came up for consideration, my lord, in the earlier occasion also, where it is that even if, my lord, this came up consideration, where it is Manik Devnath, the same Moja, same person is there. Where, my lord? This honorable court head, even if my lord Kali consider, so the application which I have filed, which is on their record, is relating to the land only. Relating to land only. So in any event, my lord, in view of the award which was passed in respect of structure, that your lordship will find at page 13.
Page 13.
Yes, my lord. Page 13. In any case, compensation not acceptable application addressing the Arbitration CG5 Act may be submitted by the office. So even if my lord Kali consider as on this day, this is a separate award notice.
This is sometime in 2015.
2015. Then also on the statutory, my lord, this is arbitration, my lord, there is limitation cannot be applied. Even if, my lord, so far, if their condition is
Are you even able to show the application that you have made before the arbitrator?
that the original application, even if my lord Kali considered what is following from a lordship, I did not apply. I filed an application that I let them accept the copy of the structure.
The present repetition will not be maintainable at all.
Now, my lord, they did not accept only this contention, my lord. Even if my lord Kali consider, if I do not produce the copy of the application which is intended to file before the authority, then also, my lord, under the statute, I am entitled to make fresh application in respect of the structure.
That is not your prayer. You say you have made an application which has not been accepted.
I intended to submit application, my lord Kali consider, because here is a direction that in case of compensation not acceptable application addressing to arbitrator may be submitted to this office by. There, my lord will not find any date.
You do not say that you intended to. You say that.
Yes, my lord, subject to correction, my lord, if your lordship may kindly consider.
my lord, kindly come to paragraph 10, my lord, page 6.
You repeatedly visited the office of the arbitrator.
Well, no
So
date
that
has
is
been
not your
mentioned.
intention. That is the application is ready, isn't it?
Yes, because I have to by personal service. That's why I mentioned. If you just says that you repeatedly visit the office of the respondent authorities and indicate to the reason for not accepting again the compensation in respect of building, but the respondent authority refused to disclose any reason but simply informed any grievances regarding assessment of compensation with regard to building and structure will not be entertained by arbitrator and the respondent authorities. Accordingly, arbitration was held for the communication of the dispute. It will appear that only grievances against the land in question was considered. This is a specific case made by me.
Please come back with a copy of the application, which has to be sent for consideration.
My lord, already they took time for filing the supplementary affidavit, my lord. My lord, kindly see the several paragraphs, my lord. My lord, I am appearing on behalf of the authorities, my lord. I don't even understand, my lord. What is the home lordship to accept any documents with the endorsement contents not verified? But my lord, repeatedly, my lord, they said we had refused to accept. But lordship, in this paragraph, no date has been mentioned. Which authorities, the name, no has been mentioned, lordship. And lordship, the paragraph 12, they said the respondent authorities ought to have accepted the application for arbitration for enhancement of the compensation in respect of the building and the structure of the petitioner. But the respondent authorities with an oblique motive refused to accept. Now, where is the denial, my lord? Where is the application? He cannot make any submission with ear, my lord. He have to come with the clean hands, my lord. Every time, my lord, in entire petitions, my lord, they said, file this application. No application has been, only prayer to accept this application.
If your lordship, though I have a copy, I have on the earlier occasion handed over to your lordship. This is WP number 1275W of 2018. My lord has a copy of this judgment, my lord.
One 10623.
1275 of 2018. Huh?
No point. বলুন না, বলছেন না কেন, বলুন।
Sagar Chandradev versus State of West Bengal.
2746.
1275 of 2018, my lord.
No, it's not there.
There, my lord, this honorable court. Nina, justification Nina.
No, it's not there.
Because the entire record was called for by the honorable court, and after that it was held ultimately. Well, may I read out after that? I can. From the aforesaid, this compensation has to be determined by the competent authority on two major counts: acquisition of land and acquisition right in nature of easement or in enjoyment user of land. There is no other distinction. The compensation has to determine either for the land as defined in the statute or rights arising out of the land more or less specified. Therefore, when the amount determined either for the land or for the said right arising out of the land as mentioned in section 1 and 2 respectively, it is not acceptable to either the parties, or either party has to allow to apply the settled government for appointment and arbitrator to determine the amount if naturally refers to compensation of the land, including structure standing thereon, and also compensation of the said stated right arising out of land. I can put it very simply. Any reference to arbitration may be either because of the party does not accept the compensation determined by the competent authority for the land and structure, because land includes the structure standing thereon, or because he does not accept the compensation determined by the competent authority for the acquisition of the said right. By reason for the context of the 3G, the reference to other property in clause C of subsection 7 in fact extends the meaning of subsection 1 and therefore also subsection 5, and may include the lands and building together than the lands including building and being acquired. The statutory scheme indicates, my lord, I'm not skipping over the, therefore I hold, after the finding, the acquisition of land under the said act includes the acquisition of permanent structure of the said land, including building and the compensation amount determined under section 3G1, such as a must also include in terms of what competent authority determines under subsection 7. Market value of the permanent structure thereon, and a person agreed by the amount compensation, even in case of the amount or sum determined for structure, can seek reference of that dispute before the arbitrator to be appointed under subsection. And if seeks such reference, the arbitrator duty bound to decide the dispute for enhanced refuse of enhancement of compensation, even on that count. But it is not entitled to refuse to accept reference or to refuse to consider the same. In view of the matter, the petition is allowed and the respondent directed to accept the application for arbitration sought to have been made by the petition in enhancement of compensation in respect to the building and structure. The record was produced, and after that, even if it is held to be a land into structure, then, my lord, it was directed as a supplementary award to be passed because there is no award declared in respect of the structure. Even if, my lord, I go to by them, I file an application for land. So, court held that yes, land. But where is the application adjudicated in respect of structure? There is no adjudicated in respect of structure by the arbitrator. Sure, arbitrator be directed to, because unless until the adjudication is made, I am not entitled to file an 34. Even if, my lord, I am taking into their account what is falling for a lordship.
Says that upon adjudication, the arbitrator has decided not to enhance the
Yes, if your lordship may kindly consider the award itself, that, my lord, will be page 20 of my writ application. Yes, 20. The submission where the award is that all the land value being paid not sufficiently by would not be able to buy the land in similar. Rather than on behalf of the NHI, it is argued that there is no reason to pay 100% solicium for structure value. For that 81-month project, it will be paid at 30%. So this is a statutory component.
So the structure part was considered.
Yes, even if by law, what is followed by lordship?
Considered, your recourse is under section 34.
Then my lord, the statutory component rather the variable component, because there is, my lord, is the rate which the compensation for structure was paid, it remain unchanged.
Yes. If you are unhappy with this, you have to take recourse under the law. That's 34. It is not that your application was not accepted, the structure was not considered, not at all. Structure has been considered and not decided in your favor.
So the market value decided not whether the statutory component can be reduced.
So that is on merits. You have to go before the.
That is why, my lord, my application was not. Where is my award? I want to put this question to myself. Where is my award? I filed an application.
You were heard by the authority.
Yes. Now, my lord,
Copy of your application is here, and you have just now stated that land includes structures.
That is a judgment. Even if, my lord, my land.
The structure part has already been decided by the arbitrator. Any grievance against this order, you have section 34. You cannot file a separate application for redetermination of the structure part. It has already been determined. So, Mr. Roy, I'm sorry. I have to dismiss. All right, if you want to withdraw, you can.
Oh, my lord, dismiss.
For learned counsels for the parties. The sole prayer of the petitioner is for a direction upon the learned arbitrator to accept the application filed by the petitioner under section 3G5 of the National Highways Act 1956 for consideration of enhancement of compensation in respect of the structure standing on the acquired plot. It is not in dispute that compensation with regard to the land has been considered by the learned arbitrator upon hearing the petitioner, who filed an application under 3G5 of the Act of 1956 before the learned arbitrator for reconsideration, for reassessment of the compensation payable to him in respect of the land acquired by the authority. Paragraph is submitted on behalf of the petitioner that the petitioner made an application under section 3G5 of the Act of 1956 before the learned arbitrator for reassessment of compensation payable to him with regard to the land in question. Learned counsel submits that though reassessment of compensation in respect of the structures standing thereon was not included in the said application, the term land includes structures standing thereon in accordance with standing thereon, stop. Now, standing thereon, stop. In accordance with correct. On a bare petition of the arbitral award, passed on 19 July 2017 is the award.
Yes.
Oh, no.
17th August.
No.
17th August,
17th August.
August 2017.
On 17th August, 17th August 2017. It appears that the learned arbitrator considered reassessment of compensation in respect of the land in question, as well as the structure standing thereon, and came to a conclusion that the rate at which compensation for structure was paid will remain unchanged. So in other words, both the land and the structure was taken into consideration in the arbitral proceedings, and no enhancement of compensation was made with regard to the structures standing on the land. Stop. Paragraph. Since it is not in dispute that the petitioner was given an opportunity of hearing before the learned arbitrator prior to passing the arbitral award, comma, in the event the petitioner is aggrieved by the said order, comma, his recourse, his remedy lies under section 34 of the Arbitration and Conciliation Act. In terms of in terms of section 3G5 of the Act, Act of 1956. PG6 of the Act of 1956. In terms of section 3G6 of the Act of 1956. Arbitration and Conciliation Act 1996. Paragraph. In view of the above, the writ petition is devoid of any merit and is liable to be dismissed. Accordingly, the writ petition being WP such and such is dismissed. Paragraph. There shall, however, be no order as to cause, since no affidavits or urgent at website copy. Sorry, Mr. Roy. Next.
It is our duty to place the case, and after that it is mine.
We will take back the judgment. The judgment of also means a copy is on record. There's a copy there in the record.
Thirteen, my lord, I appear for the petitioner.
Pursuant to your lawsuit, last direction, I am filing a report in the form of affidavit.
Have you served?
Just now, I have
Just
served.
now, my lord, it has been served. My lord, this writ petition, my lord, challenge is the acquisition proceeding of LA case number 2 of 2004-5. My lord, in respect of plot number 250. My lord, during the pendency of this writ petition, a bunch of similar writ petitions challenging the same LA case number 2, but relating to different other plots of lands which were there in the said notification, was moved before your lordship and extensively heard and, my lord, disposed of, where your lordship was pleased to hold that the proceeding has lapsed for the twin requirements of section 24(2) not being satisfied. Well, it's a reported decision, 2022 4 CHN. Your lordship will kindly, may I apprise your lordship about that document. September 2022, your lordship passed this judgment. So, my lord, nothing remains, my lord, in this report, because this writ petition, my lord, if your lordship sees the prayer, the same LA case. Prayer, my lord, it was filed earlier. That's the only difference. Prayer A, if your lordship, page 24, 25. Page 26, the LA case
number is there. Rendering the entire acquisition.
Page 26 of the report.
No, my writ petition. The judgment is before your lordship. And page 26 of my writ petition. It was filed in 2018. Prayer A, my lord, the last portion I am reading out. Since no award could be made in favor of the petitioner till date, thereby rendering the entire acquisition proceeding in land acquisition case number 2, Roman 4 of 4-5 as null and void. And if you same place, same notification. Number of plots were there. This is in respect of 250. The bunch of writ petitions which were disposed of by your lordship in respect of plot 82. Other plots were also there, my lord. Those writ petitions are also pending. My lord, those were also heard, my lord, adjourned. They are also running in the list.
Mr. Gotwal, can you see this judgment?
No, I have not seen, my lord. I have to take instruction on whether the
Let him,
LA case is
Mr.
draft or not.
Bandyopadhyay is aware of because he was appearing in this bunch of writ petitions. Mr. Soumitra Bandyopadhyay.
please give him the citation so that he
Yes,
can
yes.
see the judgment.
Because
Please consider this and come back.
if your lordship sees, my lord,
Same acquisition, the same plot.
my lord, kindly.
Our report is that, my lord, they are the post-vesting purchaser. When the award was declared, their names were not recorded in the LR record of right. That is why award could not be, my lord, passed in their name. Although it has been, my lord, issued in the name of erstwhile owner, notice has been issued to the erstwhile owner, but they have refused to accept. And the award amount is, my lord, kept pending with the, my lord, authority. If they approach before the authority, the award amount.
Sir, kindly comes to
That is our report.
page 3 of the reported decision.
Please
Mr.
appeal before
Soumitra
the National Highways.
Highway is not here because highway did not have any interest in this plot because it is a plot behind the land which highway had proposed to acquire.
Because
Kindly
here I
see-
find a 3A1 proceeding was initiated by the National Highways.
Not in this case, regarding this plot. In the earlier, the bunch of writ petitions, there, my lord, those plots were, my lord, adjacent to the highway. So there, my lord, another point was involved that whether subsequent notification nullifies the previous notification. Your lordship held that subsequent notification nullifies. Apart from that, the other points were, my lord, that twin requirements of section 24(2) not satisfied. If your lordship kindly, may I point it out at page 19 of the decision, my lord, page 19. The decision which I have handed over to your lordship, my lord, page 19.
Yes.
The lapsing is provided only when, at the top, when possession has not been taken nor compensation paid, Indo Development SUVRA. Herein, since possession of the plot in question has not been taken by the acquiring body, the question of vesting of the plot does not arise and absolute title and possession cannot be said to be conferred upon the state. The twin requirements of section 24 not being satisfied, the proceeding is deemed to have lapsed. And the other point, since the highway was involved, that was dealt with, my lord, in other paragraphs. Paragraph 40, page 20. That was, my lord, since highway was also involved. It is right that when fresh notification is issued in respect of a plot followed by a final declaration, because highway in those cases, highway, taking into consideration that the earlier proceeding had lapsed, issued a fresh notification, thereafter retracted that no, it has been acquired. Your lordship dealt with all those points. But in this case,
that is not the issue.
Not the issue here. This is simple. This is only about twin requirements and the same LA case. And what my learned friend says that he is not aware. But page 3 of the judgment, kindly see his learned senior, my lord, Mr. Soumitra Bandyopadhyay had appeared. He cannot check this plea.
Please come back on instruction.
Yes, ma'am.
Take instructions and come. Put in the form of affidavit submitted on behalf of the fourth respondent is taken on record. Paragraph, learned counsel for the state seeks to take instructions in this matter. Seeks to take further instructions in this matter. We put this paragraph, let the matter appear under the same heading on 14 July.
Lordship.
Mr. Gotwal, please check and
Yes,
come.
yes, ma'am.
Restoration.
এই যে সাইডে সাইডে পেয়ে যাবেন হ্যাঁ সমস্যাটা ভালো করে
রান করছে restoration হয়ে গেছে। Next. 14.
May it please your worship, Lord, I beg to appear on behalf of the petitioner.
স্যার আমি বলিনি my lord in this matter on my personal ground my lord I retired for this case my lord I hand over the brief to the GP my lord so I play some time.
Mr. Dey has retired from this case, sir, and he has handed over the brief. So a fresh is required to be served, I think.
Whenever it suits your lordship's convenience, Lord, kindly fix a date.
Yes,
Kindly fix a date, my lord.
yes, I'll do that. Learned counsel for the state respondents submits that he has retired from this brief on his personal grounds. Paragraph in view of the above, in view of the same above, the petitioners are directed to serve the office of the learned government pleader afresh and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 6th July. Next. 15.
In this matter, I beg to appear on behalf of the petitioner. My lord, I concluded my argument. I repeated for 3 or 4 times. So, Mr. Talukdar will start this argument.
And I am supposed to begin, my lord. My lord, in this matter, if your lordship kindly allow me to come on some other day. As
Mr. Siddiqui is appearing for the state.
yes, Siddiqui is state, but I will also need some time because there are certain decisions I am to cite and I am to distinguish also some decisions my learned friend has relied on. So it will take some time.
But this is the, my lord, third or second or third time, my lord. So, lordship kindly appreciate, my lord, I am suffering a lot. This is not the first time Mr. Talukdar is asking for an adjournment.
The last, till last
I
occasion,
never
till last
stand in the way.
occasion, He argued.
Last occasion,
Till
No.
part has gone where the state was not
The
there.
state was not there.
The presence of
Until-
the state is, my lord, material in this case because only the KMD is the, because lease was granted by the KMD.
So he has to be there. Please inform Mr. Siddiqui in the meantime if you can. I'll fix another. Mr. Talukdar, please be ready on the next day.
Yes. And
Otherwise, my lord, I concluded argument long ago.
if your lordship so pleases, would your lordship fix it at 3:30 on any day?
Motion matter.
It's a hearing, in fact. Though it is listed as motion and
Only, my lord, if report has been submitted in the form of affidavit, not detailed, my lord, affidavit in opposition.
Cannot be fixed, difficult. Come back on the next day.
there are so many matters there on report and exception.
It will not take some more time because I have completed my argument.
You have completed. I may take some time.
The matter is adjourned. Let them.
Nothing to say in the matter.
None appears for the state.
তিন দিন
respondents
আগে
on
করার পরে
15th
বলছো
day, the
যে
matter is adjourned. Let the matter appear under the same heading on 18th July.
18 July.
Please be ready, Mr. Talukdar.
Yes. I shall not pray.
Please inform Mr. Siddiqui.
Mr.
16.
My lord, in this matter, I beg to appear with the petitioner. But this is, my lord,
I appear for the KMD.
this is an unique,
for the state.
this is an unique example, the colorable excess of discretion of the state in acquiring property without following the mandatory rules, regulations of the Act of 1948. Lordship, kindly, I will do first.
Perhaps that is not the writ petition.
Have you submitted the report?
Report exception,
Yes.
report exception, all are complete.
Because initially writ petition was filed stating that altogether is
Mr.
0.8.
Mr. Dhar, Mr. Dhar, please let me finish. No.
Different pleading is.
No, not at all. Not at all.
Entire writ petition is seeking.
Not at all.
Demarcation, and the allegation is state has only partly acquired the property.
No, my lord, that is not the fact. Because, my lord, all the facts they have disclosed in their, my lord, report, my lord, altogether it's a new case. New case, they have, my lord, stated without following the rules and regulations and procedures when I enunciated in Act 1948 Act.
Let us go by
Lordship,
the records.
Lordship, kindly first, my lord,
He
may
has
I
stated
place
and
the,
what we have stated.
no, may I first read petition? May I first place the read petition? My lord, kindly, I will look, my lord, annexure P1, page, my lord, 24. That is, my lord, the deed of purchase of our predecessors. My lord, our predecessor purchased the property in the year 1968, 30th April 1968, when admittedly there was no proposal for any acquisition or requisition of that land. Now, Lordship, can have a look, page 29. Lordship will find the schedule of that property and when that deed was executed. Well, page 29, Lordship will find ইংরাজি সন 1968 সালের 30 এপ্রিল and at the bottom, my lord, filed a schedule of that land, জেলা 24 পরগনা, থানা যাদবপুর, 145 নম্বর তজি অন্তর্গত, রেসা নম্বর 151, জেল নাম্বার 13, মৌজা কসবা গ্রামে গত জেলা জরিপে 191 নম্বর খতিয়ানে 2354/2759. This was Badadag in 1968. So what our predecessor purchased the property measuring 3 katas and 2 chitaks comprises of Badadag, that is 2454 or 2759. Now, my lord, for the purpose of developing the property, now our predecessor mutated his name in the record of the Kolkata, that I have an all exception. Now, my lord, that was a general order from the state, that is at annexure P2, page 31. This was a general order with reference to the above file. This is to state that the sealing of 2.5 katas land regarding exemption of land appertaining to existing structure, including structure built before July 1978, was intimated to the LA collector by this office memo number such and such dated September 2, 1980. That means this was issued on February 16, 1981. That means 2.5 katas which were covered by structure, they were exempted from the acquisition. So our land also covered by the structure. Because of the fact, my lord will find that in page 27, the vendors of our predecessor categorically stated that from that date, they delivered the vacant possession of the land. My lord, can have a look, page 27, that in the year 1968, the physical vacant possession was handed over in favor of our predecessor at the time of purchase. Abna Nimno top at the middle, your lordship will find নিম্ন তফসিল বর্ণিত সম্পত্তি মহাশয়কে বিক্রয় করিলাম ও বিকৃত সম্পত্তিতে চিরতর সত্ত্ব দখলীকৃত হইয়া বিক্রয় সম্পত্তির খাস দখল মহাশয়কে দিলাম. So admittedly in 1968 the physical possession was handed over. Now for the purpose of, my lord, development of our property, the beforehand your lordship can have a look to the annexure P3, page 32. That is the mutation done in our name. The petitioners before lordship. Now, my lord, as my lord, the plan could not be sanctioned due to the same acquisition took place at the adjacent plot. So, my lord, the petitioner represented before the respondent authorities for demarcation and identification of our property. We are of the view that 2.5 katas were exempted from the acquisition as covered by structure. Our land, our predecessor was living there by making construction. We are living there. All the documents we have annexed in the exception to the affidavit submitted by the state. Now, my lord, this demarcation and identification was not, my lord, made by the respondent authorities, and the petitioner approached before lordship, my lord, by filing the writ application. Now, my lord, the state and KMDA submitted, my lord, the report in the form of affidavit. More or less same statement, same documents. Only, my lord, the thing is that, first of all, Lordship can level look to the report submitted by the KMDM.
Yes.
So, my lord, kindly have a look to the, my lord, report of the KMDA. Page 2, paragraph 4 of that report of the KMDA.
Yes.
KMDA টা কোথায়? এটা তো এটা। My lord, may I read for your lordship, my lord? That the entire land in CSRS plot number 2759. That the entire land in CSRS plot number 2759. My lord, got it?
Yes, yes. Continue.
Including plot number 2454/2759. That means
That is your plot.
that is my plot. That means they acquired land in RS plot number 2759 separately and distinctly, including the land 2454/2759 of Mauja Qasba, jail number 13 under PS Qasba, previously Jadavpur district, South 20 Pargana, measuring 0.88 areas in total, is fully acquired in 2 phases in the year 1976-77 and 1993-94 respectively by the LA collector, South 20 Parganas, for public purposes, that is the East Kolkata area development project. Now, my lord, it is an admitted position that they contended in their report that in 2 phases the land was acquired, 0.88 acre of land. But admittedly, I was in possession, our predecessor were in possession over the property in question. No section 3 under the Act of 1948 was ever served upon our predecessor, nor any payment of compensation was ever paid to our predecessors, nor the physical possession of the land was taken over actually by the respondent authorities, which is still lying with us. And I can show your lordship the documents to that demonstrating that our predecessor was in possession at the relevant point of time.
This is not the case made out in the writ petition.
They have disclosed this document.
If he makes.
They have disclosed this document after filing of this application, writ application. I have to deal with these documents, their case. This is an unique example, the colorable excess of discretion, that we are the state, we can acquire any plot of land by any means without following the norms, without following the rules, regulations, whatever in the statute. Now, my lord, kindly have a look. Paragraph 6. Paragraph 5.
According to you, your portion 3 cutters, 2 chotters have not been acquired at all.
Yes. Yes. Not at all.
And according to us,
Not at all.
land acquisition proceedings,
Paragraph 6
award
of my.
is made,
Not at all.
award is deposited with the court, everything is
I will,
completed.
I will show your lordship. Award was declared in the name of the erstwhile owner, but material on record shows since 1968, my predecessor in interest, for argument's sake not admitted, if the contention of the state authorities that in 77 they acquired first phase of the acquisition. At that time, out of 0.88, they acquired 0.82. That means 0.06 acre was not acquired at the relevant point of time because it was covered by structure. So if that is the contention of the state respondents, they knew it very well that my predecessor was in occupation. What prevented them from giving any notice under section 3 from declaring the award in the name of our predecessor? Now, lordship can level look at paragraph 5. That in the first phase, an area measuring 0.80 acres of land, total area of 0.88 acres of land in RS plot number 2759, excluding the area covered by structure, in Mauja Qasba, jail number 13, district South 24, was acquired in connection with LA case number LA 205 of 1976-77 for public purposes, for creation of better living condition in rural and urban areas by construction and reconstruction of dwelling places and for purposes connected therewith and incidental therein, as also for establishment of commercial and industrial estates. Calcutta Area Development Project notification being number such and such under section 4(1)(a) of the West Bengal Land Acquisition Act 1948 was duly published in the Calcutta Gazette on November 29, 1983. Possession of the said land was handed over by the concerned collector to the KMD authority on 1979. The said acquisition proceeding was duly completed and concluded by the concerned collector upon complying with all the required documents in that regard, and thereby the land vested absolutely unto the state. The government of West Bengal subsequently by a deed of conveyance being number 08844 dated 31/12/2004 transferred and conveyed the right title and interest in the said land to the KMD, and thereby the KMD became the absolute lawful owner of the said land to the exclusion of all others. That is the first phase of the acquisition. Now paragraph 6. That the remaining portion being 0.06 acre of CSRS plot number 2454. Now, my lord, kindly note it. Previously, in the first phase, it was only 2759, including 2454, 2759. Now, 2759 abolished, only 2454 slash 2759. Being renumbered. They have stated that being renumbered. From which plot number it was renumbered, that has not been disclosed. In Mauja Qasba, jail number 13, district South 24 was also acquired in connection with another LA case being number LA2, 2 of 1993-94 for public purposes, East Kolkata Area Development Project, notification being number 5606, such and such, dated 21st September 1995 under section 4(1)(a) of the West Bengal Land Acquisition Act was duly published in the Calcutta Gazette on September 11, 1995. Possession of the said land was handed over by the concerned collector to the KMDA authority on 31st March 1994. The said acquisition proceeding was duly completed and concluded by the concerned collector upon complying with all the required formalities in that regard, and thereby the land vested absolutely unto the state. The government of West Bengal subsequently by a deed of conveyance being number 13007 dated 8/11/2006 transferred and conveyed the right title and interest in the said land to the KMDA, and thereby the KMDA became the lawful and lawful owner of the said land to the exclusion of all others. Now, my lord, the KMDA has annexed the Gazette notification. They did all these things, state also. So I am not placing those documents before lordship because I have to deal with the report submitted by the state, wherein all the documents along with the award sheet has also been annexed, and I will deal with those documents. Now, my lord, kindly have a look to the report submitted by the state.
Yes.
My lord, paragraph 3 of the said report states that your respondent state the following facts of the case in brief. The suit plot number RS2454/2759 measuring an entire area of 0.88 acre of Mauja Qasba, jail number 13. My lord, kindly note it. Not 2759. The area 2454/27, that is a Batadag, measuring an entire area of 0.88 acre of Mauja Qasba, jail number 13, appertaining to RS Kotiya number 191, was requisitioned under section 3(1) of the West Bengal Land Acquisition Act 1948, hereinafter referred to as the Act 2 of 1948 by virtue of LA case number LA 205 of 1976-77 for ECAD project of Kolkata Metropolitan Development, now KMD, and the possession of vacant portion measuring an area of 0.82 acre of the said plot, excepting the area covered by structure was taken over and handed over to the requiring body, CMDA, now KMDA. Now, my lord, their contention is that the plot number 2454/2759 was acquired in LA2 case number 105 of 1997. Now, my lord, kindly have a look to the page 7 of the Gazette notification. My lord, your lordship will find right hand side, second from the top, 2454. Now, my lord, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 number from the top.
This is 1.81 acres.
Huh?
1.81 acres.
No, that is plot number 2454.
Yes.
That is 1.81 acre out of 0.73 was acquired. It is a separate DAG number. Now, number 13 from the top. Lordship will find DAG number 2759, excluding the area covered by structure, 0.82 is the land acquired. So, my lord, my humble submission to your lordship, my lord, if Gazette notification is published and in that publication the particular DAG number is not there, I put this question to myself whether the acquisition is a valid one. Because it is their case, your lordship will find from paragraph number 3 that suit plot number RS 2454/2759 measuring an entire area of 0.88 acre of Mauja Qasba jail number 13 was acquired in LA case number 105 of 1976-97. But that was not published in the Calcutta Gazette. And it cannot be the case of the respondent authorities that a Batada cannot be acquired and cannot be published in the official Gazette. So, and the moot question involved in this case that it is not renumbered because our predecessor, I will show your lordship from the record of right that when our predecessor purchased in the property in 1968, at that time this Batada was existing. So my humble submission before lordship that unless the Gazette notification is made with regard to the particular plot of land is concerned, that acquisition is not a valid one. Now your lordship kindly have a look. Paragraph, what my learned friend was saying that paid, award paid, everything paid. I am making a case without any basis. Now my lord kindly have a look to page 14. This is all with regard to first phase of acquisition, not second.
Page 14.
Page 14. This is the award sheet. You also will find case number LA2 105 2 of 1976-77. Now my lord will find, my lord got in my lord. At the bottom, Khotian number 191 RS Nagendra Nath Das. He was the erstwhile owner. I cannot deny because our predecessor purchased the property from this Nagendra Das. Nagendra Das, son of Hiro Chandra Das of Qasba, amount has been shown as 1,32,966. At the right hand side column, your lordship will find that only the amount has been written. Where is the payment? What is the details of check number and all others? Though I am disputing this declaration of awards, still what they have annexed with their report. What is that particular? This is only declaration of the amount. I put this question to myself, how the state can say that payment has been made, even it was not deposited with the LA court for recurrence. Nothing, only amount is there. Now, my lord, kindly have a look, page 17.
17.
Page 17. That is a very interesting point. Entire land value of 0.82 decimal Shali land of RS plot number 2759 P, that means portion, with 30% SA interest and RC. That is that amount, my lord, 1,32,966. What is the indication of the Batadag number? If my land was acquired, what is the indication of the Batadag number? Only 2759.
This is paid to Gauri Shankar Majumdar.
No. It was paid to Nagendra Das. This award sheet, they have annexed, not serial wise. Your lordship will find the amount 1,32,000. Your lordship will get the name of the person.
Pramod Ranjan Dotto.
Our predecessor is Pramod Ranjan Dotto.
Pramod Ranjan is in page 16. So these are all the awardees.
Abolished, nothing. No details in which Dag number it was acquired. Nothing has been mentioned. আমাদের দলিলটা কত? প্রমোদ রঞ্জন দত্ত না? আমাদের দলিলটা কত? দলিল।
Yes.
And one of the main interesting thing is that it is with regard to plot number 2759 only. Now, my lord, your lordship can have a look, page 19. That is the second page of phase of acquisition. At the bottom, your lordship will find 2759 Dag number, plot number, out of 0.88, 0.06 was acquired by publication published in the Calcutta Gazette, that is February, October 13, 1995. So admittedly covered by area covered by the notice 2759 0.88 out of 0.88, 82 was previously acquired. Now they are acquiring 0.06. So what is the plot number? 2759. They acquired as per their contention, they acquired 2759. Now, my lord, kindly have a look, page 25.
Yes.
Serial number 54, Nagendranath Das, son of Kirochandra Das of Kosba, land value of plot number 2454/2759. Now, my lord, very peculiar. The acquired land which they have notified in the notification, that is 2759. In the previous award, they have shown that only 2759 in the award sheet. Now, the Dag number 2454/2759 of area 0.06 /2 land has come into picture. I put this question to myself, how this Dag number has come into picture at this moment, only to deprive me. Now, my lord, the award so declared, it covers only land value, not the structure of the value of the structure. That is also the defective award. Lordship, because it is their case that in the first phase they acquired the land which was not covered by structure. They did not acquire that. In the second phase they acquired which is covered by structure. Now, my lord, kindly have a look to the award sheet. What is the value of the structure? Now, lordship, kindly at the right hand side would see paid as award number, serial number 5, additional LAO. What is the details? Who accepted this award? On whose behalf? Nothing has been disclosed. So the state thought that it is our land, we can acquire by any means, by any adopting any procedure which we like. They made publication, declared award in the name of person. Now I will show your lordship. In 1968, what was the actual position of the plot in question? Why my name has not been included? Why I have not been served with the Section 3 notice? Why I have not been declared the award? Now my lord, kindly have a look to our exception to the report submitted by the state. First of all, my lord, stated. First of all, my lord, I draw your lordship's kind attention to the contention made in the said exception. Thereafter, I will show your lordship the documents. Paragraph 5 of our exception, page 2. That in subclause 1, 2, and 3 of paragraph 3 of the said report, the deponent has contended that suit plot number RS2454/2759 measuring an entire area 0.88 acre of Mauja Qasba, jail number 13, appertaining to RS Khotian number 191, requisition under section 3(1) of the West Bengal land requisition.
That's what the state has said.
I state, next paragraph, sorry, my lord. I state that it is the contention of the deponent that plot number 2454/2759 measuring an entire area of 0.88 acre of Mauja Qasba was requisitioned under section 3(1) of the Act 1948, and accordingly notice under section 4(1)A of the Act 2 of 1948 was published on 29/11/1983 in the Calcutta Gazette dated 21st November 19. But if the said Gazette notification dated 29 with regard to LA case number such and such is taken into consideration, it would be seen that plot number 2454 and plot number 2759 have been requisitioned under section 3 of the said Act of 1948 separately and distinctly, but nowhere in the said Gazette notification it would be seen that plot number 2454/2759 was requisitioned under section 3 of the said Act. And law is very much settled that unless proper notification is published, so far the requisition under section 3 of the said Act 1948 is published concerning a particular DAG number, the same cannot be treated to have been vested to the state. And in the instant case also, nowhere in the said Gazette dated 29/11/1983, it could be seen that plot number 245427 was notified in the Calcutta Gazette dated such and such, and as such, the contention of the deponent that the said plot number 24542759 was vested to the state in view of publication published is absolutely not sustainable and tenable as per the provisions of law relating to land acquisition unless the plot in question is duly notified in the Calcutta Gazette. The same cannot be taken to be requisitioned or acquired in accordance with law. I further state that being the position, the whole contention of the deponent with regard to the requisition and acquisition of plot number should not be treated to have been vested. Well, this is repetition. Now, my lord, 7 line from the top. When the purported land acquisition case was taken place, our predecessor was admittedly, it should be admitted, sorry, my lord, my mistake. Admittedly, the recorded and lawful owner of the subject plot, but from the materials on record, it appears that the order under section 3 of the said Act 1948 was never been served upon the predecessor of the petitioners, who was admittedly recorded and lawful owner at the relevant point of time. And as the said Act of 1948 is a special statute by which it was embodied that prior to process of acquisition, an order of requisition under section 3 of the said Act 1948 was mandatorily required to be served upon the recorded owner or the occupier as the case may be. And admittedly the predecessor of the petitioners was recorded owner and admittedly was in possession and occupation with regard to the subject plot when the purported requisition and acquisition proceeding took place, and to that effect law is also settled that unless the said order under section 3 of said Act 1948 has not been served as per the mode of service enunciated under Rule 3 of Rule 1948, and in view of non-service of order under section 3 of the said Act of 1948 upon the predecessors of the petitioners, the requisition and acquisition of the subject property is absolutely voidable, invalid, and is liable to be quashed and or cancelled and or set aside in accordance with law. Now, my lord, next, my lord, paragraph 6 from the contention in paragraph page 5, the contention of the petitioners. I state that in the case of subsequent requisition and acquisition, the same thing happened, and in the Calcutta Gazette dated October 13, 1995, the plot number 2759 covering an area of 0.06 acre was duly published in view of the requisition under order and under section 3 of subsection 1 of the said act, that in the said Calcutta Gazette nowhere it has been published that plot number 2454/2759 of Mauja Cause was requisition for the purpose of acquisition, and as such the same is bad in law. I further state that since 1968, our predecessor was in possession and occupation over the subject plot of land, and the purported land acquisition case was initiated in the year 1976-77, and subsequent thereof, the order under section 3(1) of the said act 1948 was required to be served upon the persons entitled to under the said act 1948. But in view of rightful possession and occupation, and also in view of being the lawful owner of the subject plot, our predecessor was entitled to be served the order under section 3(1) of the said act 1948. But the fact remains that our said predecessor was never been served with any notice or order under section 3(1) of the said act 1948, which makes the entire acquisition proceeding null and void and is bad in law, and the same cannot be sustained and is liable to be quashed and or set aside by virtue of operation of the law.
Will you take some time?
My lord, judgment, I will place some judgment.
So other matters are waiting. Will you, I was actually thinking about it. Will you continue after on?
These
some other
matter, in earlier matter also, the report and exception, but the contents that requires a full-fledged hearing.
A hearing. Our matter, my lord, your lordship fixed for hearing after completion of the affidavit. But this matter, my lord.
This is at the motion stage. Affidavits have not been
My
filed.
lord, after completion of the affidavit. my
Maybe a
lord,
lengthy
we are-
matter, but affidavits are not
My
required
lord, it is
actually.
a lengthy.
Mr. Day is annoyed to excuse me because I to take some time.
Mr. Justice, we can continue.
Other courts, other yes. That I understand.
Please continue, Mr. Bhatt.
That is why in earlier matter also I was insisting your lordship to fix all these matters,
12:30.
hearing matters.
12:30.
12:30.
12:30.
Okay.
Bobby. I'm no problem. Oh, 7 except 1 and 2. The 1 is Sunday, 2 and 3, third, 7 except 3rd. 3rd of July.
18 July.
18 July উঠেও দিয়েছি 18 July দিয়েছি এর আগেরটা
The other matter is also 19.
also yes
So let this be on 19th.
It will take some
Again,
time.
two big matters.
12:30, both the matters were not
Both
12:30.
15 and 16, both.
No, 18, 19.
18 19 this is 19
The earlier one was on 18 July. Let
Genesis
this be on 19 July.
Earlier one, my lord has kept it in the motion.
12:30, both the matters were not, can you keep it 12:30?
12:30, we are appearing in that matter also. So
So let it be 12:30.
Yeah,
Both the
12:30.
matters.
Both the matters.
12:30
The second half is for group 7 matters.
Second matter and hearing, my lord, other 3:30 or Monday and Wednesday.
only
Hearing
3:30 can
matters.
be judgment.
কেন এখন দেবো কেন দাঁড়াও বলবো জয়সুকে তখন তোমাকে বলবো
Ready হয়ে আছে, সামনের দিয়ে শেষ করো।
Her learned
না
counsel for
শেষ
the
করে
petitioner.
এত তাড়াতাড়ি শেষ
Tenors.
করতে হবে।
Paragraph, let the matter appear under the same heading for further consideration on 19th July. 12:30. Bracketed 12:30
My lord.
PM.
Earlier,
এর আগের ম্যাটারটা ওটা 12:30 PM. The earlier matter was item
18.
number
18, my lord, 12:30.
item number 15.
Item number adjust.
Item number 15 and
That's what.
16.
15 টা আপনি না নিয়ে একটু বলে দিন ওটা 12:30 PM. That is so that others photo matter.
Yes, ma'am. Yes. I can understand. No.
Serious matter.
No, 18 থেকে
Serious
No,
matter.
12:30.
কিছুই নেই
12:30 টা কথা।
না, তোমার কাছে কিছু নেই তোমার তো জমি যায়নি যা জমি গেছে সে
Yes, yes, sir.
I am diplomat.
Education. My lord, this is simple matter.
17.
I am for the pitch. Didi,
Is it the your opinion?
Yes, madam.
Yes.
my certain land has been acquired by the state for development of national NH34. Award has been given, but my lord, the amount has been too much below. We made the representation. Kindly look at my lord page 14.
19.
The quantum of my lord, page 13, 3,35,997. But this is not in accordance with the market price of the land. That's why we made an application to the collector. নিম্ন আবেদনকারীর নিবেদন এই যে নিম্নে বর্ণিত দাগের এত অংশের মালিক দখলিকার হইতেছি আপনার অফিস মারফত 20/12/19 তারিখের বয়ান অনুযায়ী আমার অংশের জমির মূল্য এবং ক্ষতিপূরণ বাবদ সর্বমোট 3,35,997 টাকা ধার্য করিয়েছেন অর্থাৎ প্রতি শতক মূল্য মাত্র 15,057 টাকা মানে দিস ইজ বাই দি সাইড অফ দি ন্যাশনাল NH34 যাহা প্রকৃত জমির মূল্য অপেক্ষা অনেক কম এডিএসআর সুতি মুর্শিদাবাদ উক্ত জমির মূল্য নির্ধারণ করেছেন প্রতি শতক 1,57,500 টাকা অর্থাৎ জমির প্রকৃত মূল্য ক্ষতিপূরণ সব মিলিয়ে আমার অংশের সর্বমোট মূল্য হইবে 31,95,045 টাকা
Yes, so that this be considered by the.
yes that should be considered taking into account my documents we have attached
You will be given an opportunity.
yes,
to hear
yes
it.
to produce the
You
relevant
again place your documents.
yes
Divisional commissioner. Divisional commissioner. Malda. Respondent number 2.
Respondent number?
2, madam.
Two. Affidavit of service. Being aggrieved by the compensation. granted
arbitrator
to
and divisional Malda.
him for acquisition of his land, comma, the petitioner filed an application before the second respondent requesting enhancement of the same.
My lord, page 21 through lawyer's letter it was
আগেরটা
আগেরটা ওটা
ঠিক আছে পড়েছি
ওটা দেওয়া হয়েছিল এলে কালেক্টর মুর্শিদাবাদকে
নাও হবে না division
Enhancement of
oh
the
yes
same
yes it yes
in
right
tune- in tune with the market value of the land. Stop. The said application is yet to be considered. Stop. The petitioner pays for the direction upon the
Yes, sir.
upon the second
Yes.
respondent to consider the application at the earliest. Paragraph, it is submitted on behalf of the respondents that the second respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the second
Collector,
respondent to consider and dispose of the representation
authority divisional commissioner
Submitted.
যাকে দিয়েছো ঠিক দিয়েছো
by the petitioner
ঠিক দিয়েছো
dated such and such, ওটার আগে ডেটটা দিয়ে দিন।
তুমি authority।
application করেছে না? On 20th January,
yes yes
on 20th January
তিনটেই same।
2020.
আঠারোটা
এর আগেও
তোমার
date টা দিন।
ডাকেনি তো এখন
On, within 6 weeks,
yes yes
within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, chapter.
And 17 18 19 same
Well, 18, I'm appearing for the respondent. Lord.
At
Did I
this
give
call,
representation?
18.
18, I'm appearing for the
same one
respondent.
the date of the
Yes, same.
application is also the
same এইগুলো দাওনি এটা দিদি
18.
20th January. Same order, affidavit of service.
19.
same
Affidavit of service.
দিয়েছে because they are hormonal relatives brothers
The application,
yes yes that is there Same date.
That page,
1 second, my lord. Page 14, January 2022. Yes,
page 14.
yes, yes.
No, page 14 is,
শতদল
page 14 is the schedule.
হ্যাঁ হ্যাঁ 18 তো বলছি,
এটা 19.
17টা দেননি? ও 19. Yes.
DSC 19.
19, who is appearing for the state?
Yes, yes.
Who is appearing, Mr. There, no? 19, who is appearing? Mr.
I also know, I'm in 18.
And in in 19 page 18.
20th January, same date, but can state of None
Same
appears
date.
for the affidavit of service, but none appears for the
Which-
state
which
respondents.
Oh,
Mr. Ganguly, may I request you to appear in this one? Mr. Ganguly, appointment regularized for copy service direction. Please serve a copy of this petition to Mr. Ganguly.
কোনটার গো 18?
19.
19.
18 I'm appearing. 19.
দেখে তো দিয়ে
18 you're appearing.
yes, yes. দিয়ে দিচ্ছি দাঁড়া এখন। My lord, here and I am giving.
Yes, next.
20.
I beg to differ on behalf of the petitioner, ma'am.
I'm extremely grateful.
For the
Yes.
petitioner, my lord. And this is my affidavit of service. I have served, my lord, the state and my lord, as well as the, my lord, private respondent also. This is my,
Appearing for the state. Mr. Ganguly, you're appearing?
No,
my lord, Mr. Parthopratim Roy and Mr. Ramchandra Guchai.
I think they are no longer in the panel.
Yes, yes. Very difficult, my lord. Those who have been in the panel, they have been depaneled. We are also facing a lot of
And
difficulties.
your service upon the private respondent is also not
Let
complete.
them
My
serve
lord,
upon the
complete,
GP.
complete.
Let them serve preparation upon the GP, my lord, that will be better.
I think you have to serve the GP's office. Because the panel has changed.
Yes, my lord.
Very difficult task.
My lord,
For me or
this is
for
my
us
earlier
also we are
affidavit of
suffering.
service. This is my earlier affidavit of service, my lord. Keep it.
Affidavit of service filed by the petitioners is taken on record. None appears for the private respondent despite service. None appears for the respondent despite service. Paragraph. Since the panel of lawyers in the state panel has been altered, the petitioners since learned counsels in since there has been a revision in the state panel of learned counsels, the petitioners are directed to serve a fresh notice to the office of the learned government pleader and file affidavit of service on the agenda. Paragraph, let the matter appear under the same heading on 18th July.
My lord, only notice or my lord, petition?
Serve a notice, they must be having a copy.
My lord. Great.
21.
Lord, my Lord and learned senior, my lord, is appearing in this matter. My lord,
The petition is not maintainable.
probably, my lord, it is there. Though, my lord, in the order of the appellate authority, my lord, under section 54 of the Land Reforms Act, it has been stated.
Will you approach the appropriate forum?
My lord,
You can withdraw, approach the appropriate forum. The matter pertains to the West Bengal Land Reforms Act 1955. Paragraph, learned counsel for the petitioner seeks to withdraw the petition and approach the appropriate forum for redressal of the grievance of the petitioner. Paragraph, in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall however be no redress to costs or the subscribed website. Tell him.
22.
But I'm for the petitioner in this matter. I appear for the KMD. There are two writ petitions, 22 and 23. are identical because 23 is, but 22 is
They have been analogously heard.
analogously. It should be
They have been characterized.
because vendor and purchase are both filed writ petitions.
No, my lord, my way of understanding of the both the replays are completely different. In the last writ petition, which has not been filed by me, my vendor, he has challenged the acquisition proceeding. At least pair says so. And my case is this, my lord, that out of the acquired area, I have purchased 3 katas of land. I sought for demarcation of that area. And I drew the attention of the authority to that effect.
It
Now,
is not acquired. Your area is not acquired.
no, my lord, I'll kindly see, my lord. Now kindly turn to, I will
So
show
the
you.
issues appear to be different.
Different, absolutely different.
My lord, in
If
item number
if it is
23, my lord, I'm
Not identical.
my lord, in item
Yes,
number
let him
23,
place. Let him
my
place.
lord, the vendor of item number 22 filed this writ petition. My lord, I have the instruction to withdraw this writ petition. My lord, since my lord, it has been,
You are the petitioner.
yes, yes. My lord, I'm not covered with
Since you
the.
have changed sides, I thought you were appearing for the state.
My lord,
So you are withdrawing the secondary petition.
my lord, difficulties, my lord, I do not have the my lord,
Instructions.
instruction, my lord. So, my lord, let Mr. Pan, my lord, submit. My lord, on the next date, I'll come up with the instruction, my lord, so that. পরেরটার পার্শ্ব করবো না।
No, my lord, I'll take up my petition, my lord. If you lordship kindly turn to the page 12. The plots in question is, my lord, RS plot number 4038. At page 12, there is a second column. Your lordship will find the 4038.
Page 12.
Page 12 of my writ petition, Piyush Bhomik. Of Piyush Bhomik.
Yes.
My lord, WPA number, my lord, 27359.
Skip. Oh, the report was there. Page 12, yes.
Page 12. None of 4038. At the second crop, where the second
4038.
eight.
Yes.
My lord, total area is, my lord, 1.33 acre. Now, lordship kindly turn to page 13. Next page. This is the proceeding initiated under the, my lord, Act of 1948. Now, my lord, relevant part is, my lord, at page 14. Your lordship will find at the right of side 7-8 line, 7-8
Yes.
4038, my lord, 0.28. Kindly mark it.
Yes.
Then, my lord, lordship kindly turn to next page. At page 15, relevant portion is, your lordship will find at page 17. At serial number 4th from top, left hand side, 4th from top, left hand side, at 1.004.
4038, yes.
Yes. Now, if we add these things, my lord, then it comes to, my lord, that 1.28 acre out of 1.33. My lord, I purchased 0.05 acre. And that is,
This is 0.28 and this is?
my lord, 1.04. So, my lord, out of the purchased area, I purchased this thing. And this is being accepted by the, my lord, the KMDA in the report filed in the earlier, another writ petition. I have the copy of that writ petition. Now, lordship kindly see. Now, my lord, if your lordship kindly, now, if your lordship kindly turn to page, my lord, the law.
What is your purchased portion?
0.05. That has not been demarcated. That is exactly what I am on. Now, lordship kindly turn to, well, kindly have a look at the, my lord, the provision. Section 9. C.
Yes.
Power to enter upon land
the state government may, with a view to requisitioning land for the purpose of determining the determination by the collector of the amount of compensation payment under this act by order. Now kindly turn to C. Authorize any person to perform in respect of any land or all or any of the functions referred to in subsection 2 of section 4 of the Land Acquisition Act 1894. Now, let's kindly turn to section 4 of the Land Acquisition Act. Subsection 2. Subsection 2 at page F6. Lordship has got it. F6, page F6, subsection 2.
Yes.
Thereupon, it shall be lawful for any officer, either generally or specially authorized by such government in this behalf or for his servants or workmen, to enter upon a survey land and take labels of any land in such locality, dig or bore into the subsoil, do all other acts necessary to ascertain whether the land is adapted for such person, to set out the boundaries. Now, this is the statutory obligation on the part of the collector, my lord, to set out the boundaries. Now, my lord, if you will kindly see next, my representation at page 74. Yes. Now, let's kindly see page 74.
Yes.
I drew the attention of the authority, my lord, in stating entirety of what I have stated in the writ petition. And there is no denial to this. And I requested them to demarcate it. Now, my lord, lordship, kindly see the report filed by the KMDA in my case. They are saying the same thing, that 1.004 and 0.28. So you acquire, so whatever possession that has been handed over to KMDA, I don't have any grievance against them. Only I am asking for the relief, my lord, to set out the boundary.
Let us hear this.
My lord.
Yes.
Well, the next writ petition was brought along with this.
Let us forget
Because
about the next writ petition at the moment. Please
at this
confine your
moment-
argument to this writ petition.
yes, if your lordship kindly have a look,
To be withdrawn. So there is no challenge to acquisition at the moment. It is only demarcation,
it is yet to be withdrawn.
but we are not dealing with it now. It's only
Because
demarcation.
why the averment and challenge made in that writ petition runs contrary to this writ petition.
Not relevant.
Yes, the same vendor who has filed that writ petition, there he challenged both the acquisition, because this acquisition in two phases that has been admitted by this petitioner.
This petitioner cannot challenge the validity of
Yes,
that.
but because he has
It's
come
a subsequent
picture
purchase, that
picture
is.
in
He's only
subsequent
asking for an innocuous prayer for demarcation.
demarcation.
How do you deny or dispute that?
My lord, here one thing, my lord, may I refer, my lord? If your lordship kindly consider this paragraph 3 to 6,
Of your report?
no, of the writ petition. This averments runs contrary to the averments made in the deeds, if I am correct, my lord.
3 to 6.
3 to 6. Here says about the 71 acquisition regarding the quantum of land only.
You have admitted this in your report?
Yes. These two parts, there is no dispute. I also admit that acquisition was in two phases.
And the quantum of land, that is also.
Quantum of, yes, quantum. But what the deed says is relying on the, because he has purchased, it is the content, he has purchased 3 cutters of land out of. And what the deed says, if your lordship kindly sees the recital in the deed at page 19, the first deed annexed at page 19. In favor of the petition number 2, the 2 deeds have been annexed.
Yes.
Only to show that, my lord, other facts are not
Mr. Talukdar, why do you want to make a short matter long?
My lord,
Why do you want to make a short matter long?
yes.
You're unnecessarily.
You demarcate your land. That's all. You need not to bother
only
about my
prayers for
title.
demarcation, and you have admitted
Yes.
that you have not taken the entire land.
Don't go by my title.
Yes.
কিছুতেই demarcate করবে না।
At the same-
Demarcate করলে তো ধরা দেবে। Yes. And that too, KMD will not demarcate. KMD will not demarcate. I am not disturbing his possession.
The state has to demarcate.
Yes.
The acquiring body will demarcate.
No, why I am referring this, my lord, this two writ petitions, the recital in the deeds, if your lordship go through it, lordship will that will run contrary to the averment made in
How
the.
my learned friend is going to be prejudiced by that? Suppose I have not entered my, I have not got my title.
It is also my duty to point out.
Let us see what you're pointing out.
Yes.
তোর মামলাটা যদি করতে পারি সেগুলো তাড়াহুড়ো করে পরের মামলাটা করতে পারবি।
Lordship, kindly have a look. That here, paragraph 3 at page 4, Lordship, I am not reading entire paragraph. Lordship, out of, because here the petitioner claims, paragraph 2, Lordship will find that Marinasa BB held 1.33 acres, entire land. Out of that, 2 phases of acquisition, 1.004 and 28, these two are admitted. Then third line at page 3, measuring an area 28 acres out of 1.33 was acquired in 1973. If your lordship kindly come to now the recital made in the deed, both the deeds are identical and both one is in favor of the petition number 1 and the second one is in favor of petition number 2. Lordship, kindly come to page 22, third.
Yes.
And where is the above Syed Hussain? That is the vendor of this petitioner. Now is now seized and possessed or otherwise well sufficiently entitled to as lawful owner of that personal property, more or less 17 katas 11 chatak.
Yes, and he has sold out.
So here the next, and whereas the next paragraph also says that he was the owner of held and possessed 17 katas. Whereas in the writ petition, the averment has been made that he inherited the entire property, that is 1.33, the predecessor interest of the petition. And after acquisition in 2
Even if
phases.
that be so, from the 17 quotas, 3 quotas has been sold out. So the petitioner still. remain
17
the owner.
katas, their calculation, it is the acquiring authority can apprise this honorable court. If 17 katas 11 chatak,
Your lordship will take my evidence, report in the form of evidence. Then, my lord, it is a very shortcut matter.
shortcut.
Very shortcut matter, my lord. Your lordship will see my report.
রিপোর্টে কপি দিন চন্ডী আমরা দেন।
Yes.
Today.
Yes, my lord. Right.
Yes.
দিয়ে দেবো, ওই কালে বলুন। সেদিন দিলাম নিয়ে বাড়ি চলে
Page
এলো।
24 is clear of that deed. That how much he has sold out. He is referring 17 katas. Then next page 24.
That is what I also want
Yes.
to point out, that the
Yes.
title is not disturbed. by
And
that.
even as being Mala, the title, if I don't get Mala, I will fight with the vendor.
I am on that. If 1.28
he is concerned.
1.28 acres of land is acquired from Syed Hussain. If he held 1.33, then my land friend's calculation comes. If Syed Hussain, if his vendor held only 17 katas 11 chotak, then question remains.
How you are concerned with this?
Mala, if
Mala,
you
I am
are-
asking for demarcation of the thing.
Mr. Dev wants to say something.
My lord, if your lordship will see my report, in the report, my lord, I have specifically stated that is paragraph from 3, my lord.
Paragraph 3.
Yes, my lord. Paragraph 1 and 2, my lord, that is the procedural. And now vacant possession of the said plot, paragraph 3, my lord. Third page, my lord.
Page 2, paragraph 3.
Third page, my lord, that is the report. The
Yes, third
first
page.
1 and 2 is the, my lord, the AVTB.
Yes.
Vacant position of the said plot measuring about ato and ato records in the above two cases. LA cases has already been handed over to the respective requiring
This is
body
admitted
after
position.
proper demarcation.
Yes, that is submitted.
In the instant deed petitioner claimed that by two separate deed of sale registered on ato, they purchased an area of 3 kata each from the unadequate portion measuring about 17 katas and ato. As per ROR submitted by the deed petitioner, total area of the plot number is 1.33. And we acquired 1.284. Then, my lord, if aforesaid to LA proceeding ato and ato, these records had been acquired. So only next, my lord. So only ato minus ato 0.046 acre, 2 kata, 12 shota can of the land of the said plot remain unaffected.
That is very important.
So, my lord, that
The
is very
petitioners
short
have
matter, my lord.
purchased
And
6 katas.
last line, my lord,
Kindly,
hence-
last part of the report. Last part of the report.
Now, my lord, hence the claim as mentioned in page number 1 under list of dates that one Hassan and Hussein and become the owner of the remaining unacquired portion measuring an ato acre is far from reality. The petitioner have submitted an application for demarcation of the suit plot before the collector at the 24 Pargana, and in this connection, it is reiterated that possession of the acquired area has already been handed over to the respective requiring body after proper demarcation, unless requested by them. His office has hardly any scope to interfere with the possession of the land.
That is
That
why,
is-
my lord, I was making submission that by these two deeds, the petitioner claimed to have purchased 6 katas of land.
But that's
But
not.
at the same time admits the acquisition of 1.28 acres. If total land remains 1.33 and 1.28 admittedly acquired, then remains only 2 kata, 12 chattaks of land. How could this petitioner purchase 6 katas of land by this?
Whatever may be that, what
3 kata each. Two petitioners. There are 2 deeds. You will find at page 19 and page 43.
And you say that demarcation has been done. Demarcation of the acquired
Acquired
portion.
portion.
Has that been done physically?
My lord, practically after demarcation, we handed over the land to the requiring body.
Have you submitted a document of demarcation?
Can't submit.
The quantum of land, there is a mismatch of quantum of land. You kindly appreciate that. After acquisition admitted.
Mr. Pan, how do you respond? This is a pertinent
My lord,
question.
I tell you, Lordship. But what I my fear is this, that you demarcate the acquired area. Suppose I purchase, he sold me excess land. I will not get the possession. I will fight with him that you have sold me excess land. That cannot be the subject matter of the challenge by the KMD and the acquiring authority. Well, they are saying, I am not saying that this much portion I am enjoying the possession. This is not their case. That is false within the acquired area. But what I am paying, very well. If I found that they have sold me the excess land, I will fight with him. But what I am paying, that only I can demonstrate that allegation only when this is being demarcated. Kindly appreciate, my lord. Then only I can chase the vendor. Say, look, this is the demarcated area. You show me the sold out property. You hand over me the possession. So until this is being demarcated, I am not going to disturb their possession. So they cannot say at any juncture that look, they have sold out this property, No, they don't have any right to say.
The difficulty in demarcation.
Yes, you demarcate it.
If it is not done already.
Yes.
My lord, we have not any difficulty. But my lord,
demarcate
it is not
it.
possible for me, my lord. That is the state to take part. My lord, my London friend will take inactive part.
Kindly
Now it is-
demarcation, we
Can
not.
State interstate.
Act says the
Here,
collector
why
will mark it.
My lord,
It-
we are giving the report in that form, my lord,
It is,
that it is solely depend on the requiring body. We have nothing to say. We have already handed over the position to them.
What about the statute itself? Section 4(2) of the 1894 Act, the Land Acquisition Act.
Now at this stage, my lord, at the first stage, it is our duty. Not today, it is not our duty.
Have handed over after demarcation.
Yes, my lord,
Please
that
show
on that
that
day,
you have-
on
yes,
that day, on that day.
So
Today
please
is not.
show me a document that you have demarcated on that day.
My lord, that document
That
perhaps
has not been done. You have not complied with the mandate of law. Which
Then
you
your
should have
lordship,
done.
my lord, your lordship can have the every authority to
Let
say.
let there be a
that-
direction for demarcation of the acquired portion of the land.
at the same time, Lordship will consider this aspect also.
I'll record you.
When the petitioners themselves admit acquisition of 1.284 acres
Acquired portion. has
out
been
of 133, but claims to have purchased 6 cutters of land.
That is not your lookout.
ভুল করে কিনেছে, তাতে কি আছে?
No, that is not your business. You acquired your
My lord, that is not practical.
No, you are claiming by way of affidavit, you
Not
are
against
asserting
you.
that.
That is not against you.
You are asserting.
Offers fair.
Yes.
He is happy with the remaining portion of the land.
It seems to be innocuous, but it is not innocuous. It is deliberately done.
So let there be a direction upon the state authorities to demarcate. In terms of section 4(2).
That is the state can do. Will cooperate.
State should have done that. Yes, you have
Yes.
spoken.
Yes, certainly. But Lordship will kindly record.
I'll record your submission in its
it-
entirety. Report in the form of affidavit submitted on behalf of the state respondents. is taken up by the
এটা হয়ে থাকে না।
Paragraph for learned counsel for the parties.
আজকাটা লিখে রেখেছি।
The petitioners submit by virtue of 2 registered deeds. Dated 20th January 2022. Out of the entire area comprising about 1.33 acres. Stop. The petitioners pray for an area measuring 0.28 acres and 1.004 acres was acquired by the state respondents. Number
ও আমাকে যদি আজকে করে অ্যাকোয়ার কোশ্চেনটা বিক্রি করতো তো কি হয়েছে ওরা ডিমান্ড
within bracket TW bracket closed slash Roman 2 hyphen 71/72 and number এটা LA hyphen Roman 2 LA hyphen Roman 2 slash 2 of 1977-78 and What is the number of the second LA case, Mr. Pan?
The second LA case number is, my lord, second read petition.
No, no, LA case.
LA case. Oh, my lord, in my report, lordship will find.
One is 7778.
17,
The other-
yes.
Another one was, my lord, LA 2/15 of 70/71. 1970/71.
That is the earlier one.
Yes, that is the first one.
First one.
Second one is, my lord, Roman.
Page 4 of my report.
Of
Page 4 of my
1970.
report. Paragraph 6.
77/78, my lord, Roman 2
LA
stroke 3.
Yes, LA 2/3 of 1977-78.
আরেকটা তুমি মেনশন রাখলে তো হবে না, চিঠিটা তো আসবে না, চিঠিটা তো আসা চাই। With your lordship's leave, in next matter, since both the analogous 22 and 23, I'll come up with the later for withdrawal.
But they are together actually.
Yes, yeah, this is together.
Kindly keep it on in the next week as to be mentioned, so that in the meantime I can,
Or for orders maybe.
or for orders.
Certainly pass the order, but otherwise, my lord.
I cannot keep it pending in that case.
My lord may record his submission and keep it pending.
না না অর্ডারটা করে রাখলে
Only for the
Can I-
sake of providing the
Later,
copy of the communication
written
on the
instruction.
next day.
Because if I dispose of this application now today, the first with petition.
Or on undertaking, my lord may dispose it of. You will produce.
Will you come back next week?
Yes, madam.
তাহলে একটা কাজ করুন, এটা কেটে নিন। Mr. Pan, come back next week. Because since it's analogously heard, a separate order cannot be passed.
So, my lord, let it appear under the heading to be mentioned, my lord.
For orders, it will appear at the top.
Order, stop.
For orders, I'll dictate the order.
My lord.
Third learned counsels for the parties. Let the matters appear under the heading for orders on 27 July, June, 27 June.
27.
27.
It un-
You can take the.
Ma-
This order is not complete. My lord has.
No, I have not, actually, I have cancelled. I'll dictate it on the next day.
Yes.
Heard the matter, I'll just.
Well.
এবারে এটাই আচ্ছা আপনাকে বলছি কি
also will not be sitting today.
No, no, I am here to hear your cases.
It's for it.
It was your resolution, not mine.
No, no, no. The regulation is for otherwise, you cannot go to ask in advance order.
If you are ready, I am there, I'll hear it. Yes.
Only Rathayatra today. Correct.
I will not insist. If you're ready, I'll hear it. I'm hearing it.
91.
Lord, I appear for the
File
plaintiff.
bar first file term.
I am for the respondent.
Lord, I have served Milord all the way. He is appearing for all the respondents. Milord. Milord. Lord, may I just indicate, Milord, the facts?
State respondent?
Yes, Milord, all the railway respondents.
Yes.
Yes, Milord. Milord, the petitioners, Milord, transport, Milord, iron ore from Dai3 siding to Milord, their own siding at Milord Kharagpur. Now, Milord, what has happened, Milord, this iron ore transportation is based on red circular. Milord, the red circular provide while I load, Milord, there is an associate bridge where I have to check, Milord, the weighment and then it will go. This associate bridge, Milord, was faulty according to the railway. Therefore, Milord, there was another associate bridge which is at Dai3, Milord, which is 27 kilometers prior to my destination station. They took the material, Milord. They, Milord, checked the weighment and it was found to be overloaded. We have given, Milord, the request for, Milord, the reweighment that was turned down. Now, Milord, what has happened, Milord? We have written a letter. Milord, this is a box wagon. It has a carrying capacity of 57 tons. We have written a letter saying that according to us, this weigh bridge, which was the check weighment was carried out, Milord, is faulty. And therefore, Milord, they should take steps. My Lord, my letter is at page 181, Milord. This is the first letter I have issued in, Milord, 18/11/2022.
181.
181 of the writ petition. Milord, here we say, Milord, from for reference above, rake is loaded on 17/11, having demand number such and such, and completed on HR hours dated 17/11/2022. Commodity iron fines. Loaded quantity of the above iron from Odisha Mining Corporation, white permit number such and such, weighted and government authorized road weight bridge. But said rake weighted at Benapur IMWB on 18/11/22 and found net weight of such and such against loaded quantity of 3945910 metric ton, which detected 50 wagons overloaded, which is beyond permissible capacity. Intending EIWMB is malfunctioning or there might be procedural fault. Therefore, kindly grant permission to reweighment above rake and authority and certified MOMG EIWMB. I would be more level of verification if all accompanied by your authorized representative. They did not, Milord, acceded to my request, Milord. I had to put in, Milord, the money. Now, Milord, this situation has happened on 11 times. 11 times were overloaded. My Lord knows, Milord, the iron ore, while I take from mines, Milord, subject to valid permit, Milord. While I take out the iron ores, there are, Milord, the track receipt corresponding this, which shows that weightage that which I have received. The railway denied. Thereafter, Milord, again another letter was sent on, Milord, 18th of November, saying that again, Milord, there is a fault. After I raised a letter, Milord, the rail, Milord, come up with a checking method, which is at page 185. Here, my Lord, see, commercial department, BEP EIWME is suspended from 1830 hours on dated 21/11/2022 on 28/11/2022. During inspection, it's received that I mean found out of range. I say, Milord, this is defective. They do not carry out. They continue to, Milord, take money from me. Thereafter, since I insist, they carry out and then say it is defective. Thereafter, Milord, I made a request to refund my amount. This is in excess of 34 lakhs. No response given, Milord. Till date, there is no response, Milord. And, Milord, they say, Milord, it is out of range on 20th November. Milord, a machine cannot be out of range the day they inspected. My overloading found till 19th of 11. I continued to, Milord, insist them that my lord, you'll see, my lord, 185 page. They say it's 11 on 21/2022 during. So the inspection was carried out on 20th. So, my lord, it cannot happen, my lord, the day they carrying out the inspection, it was found to be out of range. It was found to be out of range, and my lord, therefore, I paid for, my lord, refund. That refund has not been made, my lord. My representation for refund is on page 186. And the last was on given on, my lord, 6th April, 26th April, which is at page 188. Now, there is a due to the extent of 34,76,593, which they have collected from me. So, my lord, my humble prayer, they should refund me, because, my lord, they cannot be, my lord, allowed to take money, and when it was found to be already by their inspection only.
Let us hear the.
Legal metrology is the authority to find out whether any dispute regarding weight is not. Then I have to file a report, my lord.
You want to file a report?
That is
Legal
better.
metrology has to be implemented.
My lord, I have not implemented because it is their case, my lord. They say, my lord, it was found to be.
Presence of the
Legal, yes, my lord. State is your state authority.
My lord will grant leave, we shall also.
affidavit of service on prayer of the petitioner.
Inspector of legal metrology.
petitioners, leave is granted to implement the, what is the director legal, what is the entire nomenclature? What is the entire nomenclature of legal metrology?
Inspector, my lord, inspector, legal metrology officer, Kharagpur, West Bengal unit, 134, Paschim, Medinipur.
Please give it in writing.
Yes.
Yes,
Yes, my lord.
As respondent number 7 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. Paragraph, the petitioners are directed to serve copy of the writ petition along with annexure thereto upon the added respondent and file affidavit of service on the adjourned date. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 10 July.
My lord, may I be given 5 weeks?
It will take some time because legal metrology officer, Kharagpur.
10 July.
10 July.
Sufficient time. And please serve an advance copy of your report.
Yes. Lord, the item number 120 is similar, my lord.
Not called. Please wait.
I am not.
Next.
92.
Well, I am filing one supplementary affidavit incorporating the subsequent documents issued by the railway authorities. I have already served a copy. Sorry, motor vehicles authorities.
Who is appearing for the respondents?
I am.
Have you received a copy of the supplementary affidavit?
I got it.
Now, here, initially I moved the writ petition challenging the seizure. I have said that at the time of seizure of the vehicle, no copy was issued, no seizure list was issued, no demand notice was issued as indicated in the Motor Vehicles Tax Act and Additional Tax Act. Your Lordship was kind enough to ask the learned counsel, Mr. Bandyopadhyay and Mr. Chandicharan De. Two matters are there because this is item number 92. Similar matter is item number 105. Same matter. So, they asked them to take instruction from the department and please to fix the matter on 7th of June after the vacation. Now, immediately thereafter, my client wrote a letter to the taxing of to the ARTO Motor Vehicles Inspector Enforcement, Tomluk. Your Lordship, kindly see page 12 of the supplementary affidavit to calculate the amount so that the payment can be made and can be produced the receipt before your Lordship on the next date of hearing. Now, my lord, your lordship, can you see?
$60.
16. This is the amount they have demanded. This calculation is totally wrong. Because I have made it, why it is wrong, I have indicated. Your lordship, can you see? Taking the statute itself, and I shall show to your lordship the statute itself.
Have you made a calculation by yourself?
Yes.
Why don't you hand over a copy of the said calculation to Mr.
In
Baker?
the affidavit itself, I have indicated the calculation, and copy of the affidavit has been given to him. In the
Supplementary affidavit.
affidavit, I have, your lordship, can you see page 7? I have given the computation itself.
Page 7.
Page 7 of the supplementary affidavit. This is the amount of tax, 86,306 without any penalty. And your lordship, can you see what is the amount they have calculated?
2,58,000.
No, that is including the penalty.
Including penalty, yes.
Half of the amount will be this. Now, your lordship, can you see? Page 16, your lordship, can you see again?
Yes. Page 16.
Well, violation of section 66 MB Act 1988 and penal section 192A MB Act 1988 without permit, 10,000 rupees. Your lordship, kindly come to page 31 of the writ petition. This is the permit.
Yes.
This is the permit. It has been countersigned for it while this particular period, it has not been countersigned. The plying of the in West Bengal may be called as unauthorized, but it cannot be said without permit. Section 66 cannot be attracted. Your lordship, can you see section 66 of the Motor Vehicles Act? Language is very specific in section 66. No owner of a motor vehicle shall use or permit the use of a vehicle as a transport vehicle in any public place, whether or not such vehicle is actually carrying passenger or goods, save in accordance with the conditions of a permit granted or countersigned by the regional or state transport authority or any prescribed authority authorizing him to use the vehicle in that place in that manner. At best, it can be said that the use of the vehicle is unauthorized, but it is not without any permit. Even if, for argument's sake, if I accept that non-counter signature in West Bengal amounting to no permit, even if I accept for the time being, 10,000 is all right. Okay. Then the 1500 regarding penalty, page 16 again. 1500 is also all right. I have no dispute regarding 1500. Then, my lord, your lordship, can you see Motor vehicles tax calculated for the period 17/1/23 to 15/5/23. Period is all right. I have no dispute to that. For first 5 seat 900, in addition 100. But may I put this question to myself? This is motor vehicles tax, not anything else. There is no such provision in the Motor Vehicles Tax Act. Your Lordship, kindly see. This is the schedule. Just like a boita dao.
The tax act, I have it.
Tax Act, your Lordship, very well. Your Lordship, kindly see.
79 Act?
79 Act, schedule of the 79 Act. B, because I shall be covered by the clause B, because it is registered outside West Bengal.
Yes.
This is for stage carriage A, for maxi cab, each seat. This is not maxi cab. Next, for other vehicles, each seat based on the seating capacity noted in the registration certificate 125. So per seat 125 per year. Number my seating capacity as reflected from the certificate of registration, page 30 of the writ petition, 42. Page 30 of the writ petition.
Forty-two.
42. So the calculation they have made for 5 seat 900, in addition 150 per seat. But I do not know where from they get it. At least I have not found out in the latest book of 2022. I have not found it out. My learned junior having 23 edition, there is also not there. Then your Lordship, kindly see 72 seats. May I put this question? Where from they got it 72 seats? Seating capacity.
I think the state needs to explain.
Now your Lordship, kindly see 100% penalty. It's all right. Now, this calculation would amount if they have calculated 354,580. According to me, this will be tax is, this is the calculation. Paragraph 7. Page 7. 693 rupees. As to how 693, your Lordship, kindly see 693 also I have calculated, page 6. Page 6.
Yes.
Your Lordship, can say as this I am reading from the top. As per the registration certificate of the said vehicle issued by the registering authority, Motor Business Department, Kotak, Odisha, the vehicle is of 42 seating capacity. More so, I further state that calculation of the motor vehicles tax ought to have been made as per section 4 of the West Bengal Motor Vehicles Tax Act 1979, as well as tax schedule mentioned therein under head B, where the rate of tax is indicated 125 per seat per annum. So the calculation of the motor vehicles tax for 52 weeks would be 125 divided 52, 2.40 per seat per week. For 17 weeks, it would be 40.80. 42 seats, it will be 693.60. This is the number of, this is the amount for the tax for the 17 weeks. Now, your Lordship, kindly come to the additional tax. My Lord, additional tax, your Lordship, kindly come to the schedule. 89 Act schedule. (4C). This is omnibuses registered in any state other than state of West Bengal. and plying within the state of West Bengal, 4C, has you not got it, 4C?
Schedule?
Schedule 1, 4C.
Yes.
4C. Omnibus is registered in any state other than the state of West Bengal and plying within the West Bengal as express bus, tourist bus, deluxe bus or ordinary bus, whether under a stage carriage permit or a contract carriage permit. I am covered by this. No dispute. Rupees 5,000 per seat per annum plus 1,000. Rate is also correct. No problem. Now you will also kindly see the calculation. 72 seats. I don't know where from they got it 72 seats. 42 has been converted to 72. Now you will also kindly see third, page 16, third, motor vehicle special tax, rupees 6,000 per annum. This is, my lord, you will also kindly come to the taxing schedule of 1979 Act.
This is for AC vehicles.
This is AC vehicle. ₹6,000 per annum. Now, my lord, this is, they have made it 1962 in respect of 72 seats. It is of 42 seats. And my lord, they have calculated penalty also for this category of vehicle. For AC, there is no provision for charging penalty. Penalty is leave aside. You will also kindly see the tax. And the tax I have calculated here. This is the calculation for 42 seats, page 7. Now, Mr. Debray may show to your lordship one notification of 2018. Now, your lordship kindly see this notification of 2018. তুমি তাইনি তোমার লোক পেয়েছে তো আরে ভাই ভুল করো কেন your lordship kindly see here তুমি তোমার দেবে হ্যাঁ নিশ্চয়ই I know Mr. Devrai is ready, he will show this. Initially I thought it I will not show this. Later on I changed my stand. Why lost an answer? Why you change your stand?
Yes.
Now you will also kindly see here I have 10 sleeper and this is the modified registration certificate issued by the authority. Yes, 42 plus 10.
Last paragraph, serial, paragraph 1, serial number.
Yes, yes, I'm showing. 1 minute. I'm showing. আমি তো এটা দেখাচ্ছি রেজিস্ট্রেশন সার্টিফিকেটটা। Now you will also kindly see this circular 19/1/2018. The circular given by the Commissioner of Transport Department. I don't know where is his authority to give after the statute has been formulated by the legislature. How this circular is maintainable in the eye of law, that your lordship will decide. Your lordship kindly come to second paragraph. I am therefore directed to inform you that direction issued earlier white number this dated 7/12/2009 stands withdrawn with immediate effect and registration of sleeper coaches may be allowed in the state subject to strict adherence of the provisions of the bus body coaches such and such on production of type approval of the certificate issued by the appropriate agency to manufacture bus body builder. I am therefore directed to inform you that tax shall be as per the rates provided in item B and I of the schedule as may be applicable to the West Bengal Motor Vehicles Tax Act 1979, and the tax for the berth shall notionally be computed at the rate of 3 seats for each berth, in addition to for what seats they may be actually calculated. Second, additional tax shall be as per the rates provided in item B of Schedule I of the West Bengal Additional Tax One-Time Tax on Motor Vehicles Act 1989. Now, your lordship, kindly come to their calculation. First of all, your lordship, kindly come to the schedule of the tax.
Is this applicable for your vehicle?
Yes. Because my vehicle is sleeper coach.
Is it registered in West Bengal?
No,
The first.
your lordship got the point. That's why I want to show the schedule. I need not indicate that thing. Your lordship got it, that it is for registered in West Bengal. It is registered in Odisha. And it will be covered by the schedule itself. Only the schedule. Nothing more, nothing else.
Statute. Yes.
Nothing more, nothing else. So, my lord, and your lordship can see regarding penalty. Your lordship can see in this writ petition I have indicated that since 2020 October, I wrote to the authority, please calculate, please calculate. They never take any steps. 20 gone, 21 gone, 22 gone. Well, it is not possible for a vehicle owner who is to pay the huge amount of installment to the bank to the tune of 1.5 lakhs or 2 lakhs or 3 lakhs like that, because the AC Volvo vehicle, which cost more than crores, it's not possible for him to keep the vehicle idle. He has to operate the vehicle, and he has operated, he has committed the offense, and this is the thing. But your lordship kindly appreciate as to why the penalty will be settled on me. I am not at fault. I have asked you to take it. You the person choice not to take it up, not to decide the issue.
Let the state respond to these queries. Yes.
Well, before Mr. Debra starts, only prayer I am making at the present moment, because vehicle is lying in their custody for more than a month. My laborers are sitting idle. I have to pay them. I have to pay the tax. I have to pay the EMI, all these things. Well, my humble prayer at the present moment before your lordship, that the calculation I have made regarding the payment of the entire tax from 17/1 to this period, what they have indicated, 23/5, this is 86,306. Let me deposit the amount without my prejudice, rights and contention, and your lordship can decide the issue. Regarding that notification, regarding the assessment made by them and the imposition of penalty, your lordship can decide it. I have no objection.
Lordship kindly see. First of all, Lordship kindly see, my lord, there is a provision for appeal. Section 9 of the Act. He can go prefer an appeal against the order.
Against which order?
Against the order of assessment.
The matter is pending with the principal secretary.
That is that you can raise point there.
The matter is pending with the principal
Yes,
secretary.
you can raise point there. But without payment any tax, you can ply your vehicle indefinite period. That is the law. Taxing officer, the RTO is the taxing officer.
There is a provision for appeal, Mr. Judge.
Now, your lordship kindly see, their matter is pending with the principal secretary.
That
As
is
per your
another
lordship.
aspect.
No, that is not the another
There
aspect.
is point there.
It is pending before the principal secretary, because if they do not calculate the earlier period, they will not accept the later period.
What is the matter pending with the principal secretary?
The calculation of earlier period, entire period.
Pursuant to my lord's order, my lord, on 14th, my hearing was took place. Mr. Chatterjee Junior was take time for filing written argument there.
No, 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 no.
Written
We have
submission.
not.
Yes,
Your principal secretary did not hear anything, looking after the bhangor.
that is another
We are-
thing.
No, no, no. You are not
Yes.
present there. Please
He
take
is
proper
there.
instruction.
He take all points.
Yes,
I
yes.
had a talk
He
with
has
him.
not heard anything.
I had
And
a
after he has making his submission.
Yesterday,
for
I had a
duty.
talk with him.
Yes, yes. He
Yeah.
will not say anything. Let him, your lordship kindly ask him to file an affidavit. Let him put into box. Let me cross-examine. What he has heard, I will ask him.
Your learned junior cannot.
Yes,
get
my
time.
junior will also
Adjourn.
make.
Cannot take adjournment.
No, 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 no. The principal secretary asked him after the hearing was done, if you want, you can file a written notes of argument. It is for your wish. And we have filed on tomorrow, yesterday. We have told them that we will file on Monday. I have told file it on Monday.
But this is for a different period.
Yes.
This is for, but this was also within the hearing matter.
2021, they are
Different
applying.
vehicle also, it's not the same vehicle.
Yes.
Same vehicle,
This is also the same vehicle.
same vehicle.
But the period of tax.
Period of tax is another aspect.
But Manan,
This is
your
another
lordship can see, if they do not take the earlier period, no question of later period. Earlier period has to be calculated by them. It is a continuous process.
There is a provision for appeal.
Well, provision for appeal is there in a case where the authority followed all principles of law. Here the authority did not follow the.
Where is that stated?
Yes, yes. And your lordship can see when this
Point before the appellate forum.
when this jurisdiction has been exercised wrongly, there the alternative remedy is no point at all. And it is not that it could is powerless.
You have challenged the calculation, not
Read
the
co-
jurisdiction.
I have challenged the jurisdiction also because I have challenged also the calculation as made beyond the jurisdiction, beyond the taxing statute.
Beyond the statute is a wrong calculation, sir. It is not beyond jurisdiction. The authority was empowered to make a calculation which has been wrongly done, according to you. It has been exaggerated. You can move the appellate forum. This is not beyond jurisdiction.
Well, read
Not
petition
that-
pending here before your lordship. Your lordship asked them to take instruction because initially I have filed the read petition that the seizure is absolutely illegal.
An order has been passed in the meantime. An order has.
On
been
my
passed.
request.
Right.
On my request, I have asked them to calculate. Your lordship kindly see, yes, what? No.
I have handed over the seizure list to the driver
Section
concerned.
9 is very clear, Mr. Chatterjee.
Yes, and it is very clear.
An order by a tax.
I know it. It is very clear. There is no appellate authority in
Yes,
Midnapur.
yes,
Who is the appellate authority?
District magistrate.
He
District
is
magistrate
the
is
higher
appellate
authority than the principal secretary.
Principal secretary, another issue.
Not another issue.
Another issue.
What he is saying, another issue.
It is not same issue.
Your lordship kindly see what is the read petition number?
I'll fix this on the same day.
Your lordship kindly see what is the read petition number?
When is the other matter fixed?
12347. 12348, item number 98. 95 is the hearing notice. 105. Same matter.
This is not same.
What not
It is
same?
not at all same.
Item number
Same.
105.
1, 2, 3, 4, 8.
It is a different issue.
What different issue? On the tax itself, on the same period.
Same period. Nothing.
Same period.
No. Since 2020, buses
No.
flying without a payment.
No.
Any tax.
No. It is also same period in respect
No,
of that.
impose everything all right.
Well, what is their answer? Why they did not calculate?
We have fully calculate.
Where?
fully
Where?
submitted before your-
Where? May I put this question? Let them produce, let Mr. Debrai produce the calculation tomorrow from 22.
I
This.
shall produce the report before your lordship. Lordship kindly direct me to. produce the report.
And your lordship kindly see in the report itself, in the hearing notice, the read petition number 25955, the earlier read petition of this read petition is there. And your lordship please to pass this order, setting aside the earlier order.
Completely different issue. Here Caesar was made, then Mr. Chatterjee says, same issue, same issue, same issue. Caesar is a.
Let him say what is the complete different issue.
Yes.
Let him say only saying
This is
complete.
also for calculation of tax and additional tax, the other matter.
Vehicle cannot ply without the payment of tax. Why is vehicle plying?
No dispute, no dispute. It has been seized also.
Then he has to pay the entire tax and additional tax as per statute.
The
As per
calculation,
statute.
your calculation is apparently not as per
Lordship,
statute.
I got my full instruction. If your lordship kindly direct me, my lord, I shall file a report to that effect.
When is the other matter? This is the other, where the matter was heard. It is this matter where it was heard by the principal secretary.
Yes, yes.
No, this.
Yes. Who said no? Who said?
No,
Your lordship can see this matter, earlier, later matter. This is the repetition number. Here is 12347. 12347 is not there, but 25955. Serial number 5 is there. 25955 is the order passed in the writ petition. Your lordship needs to pass this order for calculation of the principal secretary. 25955.
Regarding earlier 20.
What earlier? The same calculation. Same calculation.
Occurred on 23.
Period of calculation is different in these.
Yes, 23 occurred, incident occurred on 23. He is asking for relief on 2021.
Now, 12340 it is there. The same calculation. Heard by the principal secretary. So question of appeal against the order of the principal secretary will not arise. He is acting as a
No question of principal secretary.
he is acting as the taxing officer.
This is the independent order passed by the taxing officer.
No.
Yes, independent order. Caesar is the independent.
The later matter is pending before the principal secretary. The later matter is pending before the principal secretary, 12348.
This is also 25955.
Regarding relief, short for 2021.
25955.
This is 12347.
That's right. Your lordship kindly come to page.
Here the taxing officer has passed an order.
Yes.
No doubt. Regarding calculation, your lordship sent the matter before the principal secretary for calculation. Issue is the same. There is no change in issue.
There no Caesar was made. Here
Maybe, but the issue is the same.
No, maybe.
Issue is the same, but this also has to be sent to the appellate forum for.
Yes.
For this particular period. And the read court is powerless to take into issue. Am I to believe that thing?
Powerless. Why will the writ court take this matter?
Because utmost illegalities have been done by the authority.
Issue is lockdown period, exemption of tax regarding lockdown period. Now
The order was not without jurisdiction or in excess of jurisdiction. The authority had the jurisdiction to pass.
At this point, they could have taken on 19th May.
This is a
Once this is admitted, your lordship asked them to take instruction. Is there any scope for taking such point? The preliminary objection regarding maintainability. They did not take the point of maintainability on 19.5. Your lordship kindly see.
That is lockdown period exemption.
19.5 they did not.
Caesar, two vehicle is seized. One is
Your lordship kindly see 19.5 what?
92, another is 105, another.
Whether they have taken the preliminary objection regarding maintainability of writ petition, existence of alternative forum. No.
In this writ petition, it's pending before the principal secretary. In the meantime, your vehicle has been seized, isn't it?
That's right. And immediately I moved the writ petition before your lordship.
Course of action.
You will not allow me to complete my sentence. Now, immediately I moved the writ petition.
Illegally committed.
Mr. Bandyopadhyay and Mr. Chondicharan, they appeared in the matter. In two matters, they did not take the point of maintainability of writ petition. Your lordship kindly see.
Last day of.
Maybe last day or first day.
Anyway, I cannot raise any point.
It was not taken on the earlier date. He's raising it today. What is the difficulty?
Can they, after this, after vehicle has been seized for so many days, if they took the point on that date itself, I could have preferred the appeal on the day itself. Vehicle could have been released.
If you are on limitation point, I'll.
Vehicle could have been released. No question of limitation. Well, your lordship can see my vehicle has been putting into idle. I have to pay the entire EMI, all these things. And they are only objectives collection of tax when I am agreeable to pay the tax. Where is their objection for taking the point of?
You pay the entire amount without prejudice?
I know.
Will you
In-
deposit?
And I have shown to
You
your,
don't need to pay, will you deposit before the Registrar General?
I have shown to your lordship that the calculation they have made is out and out wrong.
That has to be
Out and
decided-
out wrong.
That has to be decided by your lordship.
Mr. Debra has to respond to that. He has to show the basis on which they have calculated,
Yes.
isn't it?
Well, I have served them this supplementary, this is their
Are you
copy.
Deposit the amount before the Registrar General without.
Then the
prejudice?
amount I have calculated, I have deposited that.
Not,
2,58,000 is not the amount. Cannot be that amount.
you will get it back if the
I'm
matter
not-
is decided in your favor.
It is very easy to say all these things. It is not possible for a person to deposit 2,58,000 into two, in respect of two vehicles.
Come back with a report in that case.
নয়। আমার এই কাজটা যে কাগজটা
If you
দিলাম,
choose to prefer an appeal, I can condone the limitation period without wasting further time.
There is no, my lord, against the order of the principal secretary, against the order of principal secretary, the district magistrate is not the appellate forum, number one.
যে
This
taxing
is not
officer
the
order.
order of Principal Secretary, this
It
is
is
the
a
order
Purva
of the
Mendipur
taxing
taxing
officer.
officer.
In this case, please confine your argument to this case.
Yes.
The calculation has been made by the taxing officer, you're aggrieved by it, isn't it? What is your prayer here?
My prayer, initial writ petition prayer was to release the vehicle because the seizure is illegal. সময় নষ্ট হবে।
Yes, because the tax was not calculated, it was not given to you. So now it has been done subsequently. So if you want to still.
So your lordship pass the order that the appellate forum is there. If my client wants to prefer an appeal against the order, they let him go to the appeal or before the division bench, whatever he likes. This cannot go on because they will not hear anything.
For learned counsels for the parties. Paragraph at the outset. The petitioner is aggrieved by the computation of tax, additional tax, special tax, and other fines made by the regional transport officer Tomluk, Purva Medinipur on 3rd May 2023. Paragraph at the outset. Learned counsel for the respondents challenges the maintainability of the writ petition on the ground that the said order is amenable to appeal. Paragraph. The order of the taxing officer / regional transport officer, Tomluk, Purva Medinipur is amenable to appeal under section 9 of the West Bengal Motor Vehicles Tax Act 1979. And section the appeal provision in the additional tax
Section 22.
22.
22, my lord, additional tax.
Section 22 of the West Bengal Tax and One-Time Tax on Motor Vehicles Act, 1989.
Paragraph in view of the above, the writ petition being WPS such and such is dismissed as not maintainable. Paragraph, however, liberty is granted to the petitioner to approach the appropriate appellate forum for redressal of his grievance. Paragraph, in the event the petitioner prefers an appeal within 15 days. 15 days from date, comma, the appellate forum shall decide the appeal on merits without dismissing the same on the ground of limitation.
Madam, may I pray only one thing? Madam, the submission I have made regarding the wrong calculation of the tax, you also kindly record that.
Capital line যেখানে কি বললাম is agreed by the calculation যেখানে বলেছেন ওখানে লিখুন it is submitted on behalf of is agreed.
I also deny the allegation.
Learned counsel for the petitioner submits that the entire calculation has been made arbitrarily by the authority, dehoors the statute itself. Paragraph, learned counsel for the state respondents denies and disputes the submission made on behalf of the petitioner. Last time. No, it 1, 2, 3, 4, 7. 92. Should be 92.
But the same order to be passed in
105.
105.
105, it's pending, isn't it? Before the authority.
105 is identical, my lord. 2 vehicles are seized.
Till now, Mr. Devraj says not same matter. Now he is saying same matter. Very well.
Same method.
Very well.
This is pending before the principal secretary.
Yes.
So the same direction cannot be given.
No, Caesar list. So 105 to Caesar list.
This is pending with the principal secretary.
Yes.
14th hearing has been taken place.
So we have to
I
wait
don't
for the
know.
result.
95 দিয়েছেন কোনটা দিয়েছেন
105.
105
হ্যাঁ,
কোনটা
105 ঠিক আছে ওইটাই
Caesar list তো Caesar list
Yeah.
Let it be
তাই
called.
তো Caesar list দর্শক লিখি
93.
93.
Madam, I am for the respondent. I am led by Mr. Sonojit, Group 1 Council. I am the Group 2 for Railway. But kindly I prefer not to take. He has the.
The petitioner,
Yes, ma'am.
here again. On prayer of the respondents, the matter is adjourned. On prayer of the respondents, the matter is adjourned. Let the matter appear under the same heading on 12th July.
कागज नहीं ये कागज लो
94.
94 madam, I am for the petition.
करेंगे Here, my lord, hearing took place, my lord. Last 14th, thereafter to time for filing.
No, why he has said we have taken time? We did not take any time.
Secretary told me.
Secretary, if the secretary told him falsely, what can be done?
Lordship kindly fixed it on next week, any day.
If the secretary told you,
I
your
shall file a report
client
to that effect.
gives you instruction, wrong instruction, I am not responsible for
Hearing
it.
took place.
Hearing took place,
Yes.
your principal secretary asked my junior, if he wants, he can submit a written notes. He has started written notes.
That is why he has not passed any.
Why
order.
you have said you have taken time? We did not take any time. It was his desire. Just so that we will file a written notes of argument. We have indicated that we have already filed written notes of argument.
Anyway,
Even then,
I
he
shall
asked him to file another
I shall
written notes of argument.
communicate today. To pass the necessary orders, Lordship kindly fixed next week any day.
Your lordship kindly see the order dated 15th of March, then 15th of May.
Hearing has been concluded.
Hearing has been concluded on 14th of
14th of June.
June. 14th of June.
We're waiting for the order. Learned counsel for the respondents, learned counsels for the parties submit that in compliance with the earlier orders of this court passed on 15th March 2023 and 15th May 2023, hearing has been concluded. Learned counsel, paragraph, learned counsel for the respondents seeks accommodation to submit the report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 10th July.
He is asking for a 1 week time only.
Next
Any
week
day, any day,
will
Lordship.
not be possible. Come back on 5th July in that case.
Fine.
Next.
July.
95.
Check 95, I am appeared for the respondent number 3.
Petitioner.
Mr. Satvik Bhattacharya.
No one, not today.
My lord, I am for the petition, my lord.
96, my lord, yesterday your lord told me that you have to show me the documents. So, my lord, first time showing, my lord, this is Lord, এটা দেবে Queen একটা My lord, this is your lordship's order dated 20th April 2023.
It is on record.
Lordship. So, my lord, now I am showing your lordship after obtaining the order, judgment copy from the learned advocate of the petitioner. The postal authority was made the party in the said suit first. Number 2, my lord, collector and BDO was the party. Now, my lord, their cause of action was there, that BDO threatening the owner of the land, and that's why he declared suit, declaration suit filed before the Tiharta court. Now, my lord, I'm showing your lordship after obtaining the judgment, the postal authority given a letter to the head circle office. This is page number 1, my lord. Lordship, can you see? Regarding claim for area house rent of Shikarpur sub post office building. Lordship, I'm showing my lord one by one. Lordship, kindly give me permission. The applicant submitted the copy of the court order under TS number so and so in the court of the Land Civil Judge Division at Tiharta, 30th January 2017 as judgment copy. In this connection, as per office record, it is intimated that the house rent is stopped since 1st March 2009 as the land where the post office building of Shikarpur on plot number 1464 covering with area 11 decimal was declared as vested to the state by the BLLRO. Korimpur 1 by memo number such and such. This letter sent to the circle office. Then, my lord, we have given a letter to the also BLLRO that whether the land is vested or not, because
Relevant, sir, after an order, after a decree of the court.
Lordship, because we have given a letter to the RTI. My learned friend showed your lordship yesterday that RTI application. Now, my lordship, can you see the page number 71, bid petition? We have given them answer. This page is not showed by my learned friend. We have given the reply.
It has been annexed by your learned friend, madam.
Lordship, the required information is as follows. Matter has been taken up with the higher authority. After, Lordship,
He has shown this to me yesterday.
Higher authority already taken. Now, my lord, showing my instruction, page number 4. What showed? Lordship, kindly see page number 3, page number 3. My instruction, 2 days. In reference to the above mentioned subject, this is to inform him that the suit plot number 1464 of an area of 11 decimal of Muja Baripara, jail number 119, where the present Shikarpur post office is situated, is vested to the state, and the plot is incorporated in Collector Nudia Khutian number 1 by case number such and such in the name of Medinipur Jomindar Company. Now, TA case being number 2014, arising out of CU number 44 of 1985, in the matter of Mrs. Carbo Ceramics Limited versus the state of West Bengal, is pending before the Honorable West Bengal Land Reforms Tribunal, in which the suit plot is involved. Therefore, if your lordship pass the order, then BLLR and BDO should be made the party in his application, because that cause of action is separate and this cause of action is separate. They are challenging the rent. To whom I will pay rent? Your lordship kindly direct me to whom I will pay rent. Who is the owner of the said plot? Lordship kindly direct me.
Very simple.
Petitioner.
Got the title suit.
My lord, if the land in question is vested, if the West Bengal Land Reforms Tribunal is main matter is pending, then whom I will pay, my lord?
File an application and keep it pending without moving. It is not the concern of anyone, madam. The civil court has declared the title of the petitioner.
Now, after obtaining the order, I have already inquired. His department. I am the postal department. I am not the party in that said suit. So I have no authority to give a rent to anybody else without knowing.
In accordance with section 116 of the Evidence Act, the tenant cannot raise question as to the ownership of the petitioner, my lord, the landlord, my lord.
If the land in question is disputed, then how?
Authorities is only the tenant, my lord.
Tenancy already.
He cannot raise such question, my lord. And
This
my lord, this writ petition is with regard to, my lord, the tenant rent, my lord. This is not with regard to, my lord.
My lord, and
any
lordship
question
kindly
as
show
to the
page number 4. In whom? Today's date. Lordship kindly show.
How much time will you take to?
No,
pay the
no, my
entire-
lordship kindly see this page.
I have not asked you a question.
This is yesterday's date. 19 June 2023. Lordship kindly see page number 4.
Your voice will not really help you, madam.
Lordship.
Please lower your
Right.
voice.
Sorry.
How much time will you take to pay the entire rents to the petitioner? Please give me a time limit.
Still now their name is not recorded.
To pay the entire area rents to the petitioner.
Postal authority concern is present here.
Please ask your client and tell me. 1 month, 2 months, how much time will you take? You have to pay the entire area rent.
Still now my lord Raj's name is in the name of state of West Bengal.
How much time will you take? Otherwise, I have to give a direction.
Time living.
You cannot beat about the bush and avoid payment of rent for such a long period.
Without having agreement,
area
without
rent
executing.
About, my lord, 2,58,000, my lord. That has not been paid, my lord, from the month of February 2009 to till date, my lord. My lord, and my lord, if your lordship be kind enough to come into come page, my lord, 13, my lord.
13.
13, my lord, of my writ petition, my lord. There is a prayer portion, my lord.
Yes.
My lord, a writ or writ in the nature of mandamus do issue commanding the respondent authorities to make payment of the said area rents of 2,50,500 at a rental of rupees 1,500 per month, and which is lying dues from the month of February 2009 up to the month of December 2022. But this amount is calculating from the month of February 2009 to up 2022
Still be till date.
till date, my lord. And my lord, the petitioner also seeks another directions to the to be given to the respondent authorities to enter into a fresh agreement, my lord. Since the authority has served a notice upon the demise mother of the petitioner, thereby intimating that the authority that there is a rule of the respondent authorities to enter without entering any agreement, the authority cannot retake any cannot retain any position of a property, my lord, of private land, my lord. My lord, annexure P2, my lord, 25, my lord, page 25, my lord. May I read, my lord?
This was issued by the authority.
Yes, my lord. Addressing to the deceased mother of the petitioner, my lord. My lord, after the expiry of the lease in the month of November 2008, the authority has not entered into agreement to the petitioner also, my lord. My lord, my lord, my humble submissions before your lordships, my lord, kindly give directions to pay the area rents and also to pay the monthly rent regularly, and also, my lord, to give a directions to enter into a fresh agreement, my lord, with the petitioner.
Yes, madam. You're agreeing to the amount of rent, no dispute. That this rent is payable by you is admitted.
If the land is wasted, valor
Not
without
vested, that
inquiry.
is decided by civil court. The land is not vested, it belongs to the petitioner and no appeal has been preferred against the judgment.
Higher authority means higher authority already gone to take steps.
Who is the higher authority, madam, above the court?
Collector is the higher authority.
The court
No, above the court, nobody is higher authority.
preferred an appeal against the judgment of the court declaring the petitioner's title.
That's why, my lord, I'm
Preferred an appeal? No.
No.
no, that they didn't know, because collector is the main authority. Collector was the party. We are not the party in that says suit, my lord. That is the main problem. Just you kindly try to understand, my lord. Collector was the party. So I prayed before your lordship that collector and BDO should be made party in this application, because they are the answering authority. We are only rented. Because we are not party in that state suit. That is why, my lord.
For the degree. Who were the respondents?
BDO and collector. Page আমি বলছি এটা দেখাও ফার্স্ট টাইটেলটা ডাকুমেন্টের কপিতেই তো আছে Decision with reasons, my lord. 45.
My lord, page 58, my lord.
58. 58 নাকি? It's 58. Collector.
My lord, the judgment and decree was passed upon the, my lord, in a contest suit, my lord. And the collector has not prepared any appeal, and no such proceedings as to the with regard to any questions involving the property is vested or not is not pending before any court, my lord. But so, my lord, this is a settled, my lord, and it has been admitted by the authorities also, my lord, and there is a reason judgment, my lord.
Collector
That
should
I
be
will-
party, my lord. Without him,
But my lord,
who will give answer?
Know whether the collector or the BDO has preferred an appeal against.
no,
the-
no.
Only
No appeal has been
presumption.
prepared, my lord, till yet.
How you say? Collector should be
You are not in
party.
a position to say. So why don't you quickly implement them as parties?
That's why.
The state will appear.
State also not party, my lord. That is the
My
problem.
lord, this
I live in
writ
a
petition
people
is
postal.
against the postal authorities, who is my tenant, my lord, and the tenant cannot raise question as to the ownership of the petitioner, my lord.
Different.
And the petitioner is the owner, and he is in possessions that has been decided by the civil court, my lord. My lord, upon deciding all this question, the petition, the respondent authorities who has no local right to raise such a questions, but as putting
He is absolutely
making
correct.
submission before your lordships
But-
that this is a
But we'll give the answer that the collector has not may prefer any appeal. I also don't know. Only collector should be made party.
Madam, you have to pay.
Collector should be made party, my lord.
Third learned counsels for the parties. How long should you take?
3 months.
1 month?
3 months.
3 months? Fine.
my lord, kindly along with my lord interest, my lord, since this is area rent, my lord.
They don't know who is the owner. That's why they didn't pay, my lord.
The court has declared ownership.
The court declared in the year 1917, my lord, 2017, my lord. And
So have you paid after 2017?
after 17.
Have you paid a farthing after 17?
No, my lord, because we know that it is vested date. We are giving correspondences.
Not
No,
important, madam.
that
What
is,
the
that
court
is.
has declared is more important.
Hmm.
isn't it?
Then me,
The wrong notion that cannot help you.
2017, your lordship kindly.
Right, you
Hello.
have paid till 2008. Your defaulter since February
2008,
9.
2009.
Defaulter since February 2009. at
Nine.
You have not paid. Third learned counsels for the parties. Parent. It is contended on behalf of the petitioner that the petitioner.
My lord, one question only. Ms. Shefali Bishas made complaint before the authority concerned. So they stopped that paying rent because they are at dispute.
My lord,
Shefali
he is the
Bishas,
neighbor of the
that-
petitioner, and that.
It is already annexed.
My lord, that letter was written in the year 2008, and but subsequent to that letter, the title suit was filed and decree has been passed in the 2017, my lord.
That is annexed one বোধহয় P1 দেখাচ্ছে।
After report.
হ্যাঁ, এটা আছে annexed complaint. After that, they given a letter.
Where is the letter?
They given a letter to the BLLRO that one complaint lost. So what happened?
Where is the letter?
Later, my lord,
এটা
annexed.
না annexed P1 বোধহয় দেখো তো দাঁড়াও দেখছি আমি। তো কাগজ না তোমার?
এই তো, এখানে।
না আছে।
Report.
রিপোর্টে দেখো না তোমার
Well,
অরিজিনাল দেখো না।
Report ওই
অরিজিনাল অ্যাকাউন্ট
annexure A, my lord. Or the first report, my lord.
Annexure A
A,
to the report.
report, my lord.
report.
And where is the lease agreement?
This is
My lord,
not eligible, my lord.
I am putting this question to myself, my lord, whether the contents of this letter is known to the Shefali Bishas, my lord. Whether he has any knowledge about this letter.
Submission.
They have got original complaint, my lord, with the record, my lord. দেখো তো একটুখানি অরিজিনাল রিপোর্টটা দেখো। এটা তো এলিজিবল না, তোমার এই লেখাটা একদম
এই তো annexure, এটা তো Shefali Bishas letter তো আপনার রিপোর্টে, ওটা না, ওটা লিজ এগ্রিমেন্ট।
দাঁড়াও, শেফালি বিশ্বাসের চিঠিটা অরিজিনালটা দেখো। I'm showing, my lord, original record to Shefali Bishas complaint, my lord. Lordship, may I show your lordship?
You have annexed it?
Yes, my lord.
It is not annexed.
A, my lord. Of the report of the respondent authorities, my lord.
Today's report?
No,
No, my lord. Earlier, first report, my lord.
first instruction. This is the original, my lord. May I show you, lordship? It was the recording. This is dated 7th May 2016. They received, my lord. 2010. This is that's why they have not given rent. This after obtaining this complaint.
This is a 2008 letter.
2010. কোনটা দেখাচ্ছ? এটাই তো complaint.
2008 letter.
Yes, ma'am.
And where is the rent agreement?
Rent agreement, my lord. My lord, first agreement was entered into in between the deceased father of the petitioner, my lord, and the respondent authorities. That is, my lord, annexure
Page
P1, my lord,
25.
25, my lord.
25.
And my lord,
Valid up to?
page 25, my lord. And thereafter, after demise of the father of the petitioner, the respondent authorities entered into fresh agreement with the deceased mother of the petitioner, my lord, as at page 26, my lord. Annexure P3, my lord.
25 টা তো তোমার এসেছে।
And before expiring this, the period of this lease agreement, the respondent authorities stopped paying rent, my lord.
Your mother died, that's why.
No, that's,
Ah,
no.
mother died, did you vacate the property? Or you just?
No, no,
started
no,
it?
no, my lord, no, no.
You should have vacated, isn't it, when the mother dies?
Two thousand.
It is contended on behalf of the petitioner.
Use agreement is, agreement.
No, no.
Mother of the petitioner, Krishna Prasad Juardar, comma, since deceased, comma, entered into a lease agreement with the respondents
এটা
on
আপনার
May
আমার
10,
registration এ দিয়েছি।
1994.
First instruction. ঠিক আছে, এখন না শোনো না অর্ডারটা।
And the period of lease was extended from time to time. Stop. Upon demise of the complaint, a fresh agreement was entered.
My lord,
Entered into between the mother of the petitioner,
16/12/2003, my lord.
Meera Joardar, comma, since deceased, and the respondents on 14/11/2003.
No, my lord, 14/11, a letter was written to the mother of the
The
petitioner, my lord,
agreement is 17 December 2003, I think.
17 December.
On 17 December 2003 for a period of 5 years, which expired on 16 December 2008. Stop. The respondents stopped payment of rent monthly rent from February 2009 on the plea that the property in question was vested with the government of West Bengal. Stop.
I should kindly record that Ms. Shefali Vishwa's lost complaint from
I
that
will
period.
record your submission.
Lordship.
In a title suit filed by the petitioner being TS 33 of 2013 before the 13, comma, the learned civil judge within bracket junior division, bracket closed, Tehotto, comma, Nodia, comma, by a judgment dated 30th January 2017, declared the petitioner's title in respect of the property in question with a further observation that the property was not vested. Stop. The petitioner has prayed for a direction, has prayed for issuance of writ in the nature of mandamus, commanding the respondent authorities to make payment of the arrear as well as current rents from February 2009 till date, along with 10% compound interest thereon.
You put
It is submitted on behalf of the respondents that the respondents stopped payment of monthly rent to the petitioner / his predecessor in interest upon receipt of a complaint from one Shefali Biswas stating that the property in question is vested with the government of West Bengal.
In the year 2008.
ওই যেটা লেটার বললো না ওটা on 25th June 2008 এই শেফালি বিশ্বাসের চিঠিটা 25th June 2008 on from Shefali Vishwas on করুন on 25th June 2008 stating that it is not in dispute that the respondents are tenants under the plaintiff and have defaulted in payment of monthly rent since February 2009. The judgment and decree of the civil court declares the title of the petitioner in respect of the suit property and also holds that the property is not vested with the state. Stop. The judgment has not been carried in appeal by the state authorities who were impleaded as defendants in the title suit. Stop. In view of the said judgment, comma, it can be held beyond all reasonable doubt that the petitioner is the owner of the property in question and is entitled to monthly rents from the respondents for the same. Stop. Since admittedly, the respondents have refrained from paying monthly rents to the petitioner from February 2009 till date, comma, the respondents are directed to pay such rents from February 2009 to May 2023 at the rate of what was the
10%.
what was the rent?
Rent, 1,500. 1,500.
1,500 at the rate of rupees 1,500 per month, along with simple interest thereon at the rate of 6%. Stop. The agreement paragraph entered into by and between the mother of the petitioner and the respondents have admittedly expired. A letter issued by the Superintendent of Post Offices, Noida North Division, Krishnanagar, on 14th November 2003 demonstrates that as per existing departmental rules, a lease deed is required to be executed by the house owner for a period of 5 years for every rented building where the departmental post office is functioning. Stop. In view of the same, you will execute, isn't it? The petitioner shall execute a deed of lease in favor of the respondents for a period of 5 years with effect from 1st July 2023. Within 2 weeks? Within 3 weeks from date. Paragraph with the above instructions and observations, the petition is being WP successfully disposed of. No order is recorded.
My lord, kindly, this record should be read. Page number 4, my lord. 2 days later, the record that still now their name is not recorded. That West Bengal, state of West Bengal is the rights name, my lord. Lordship, kindly record it, my lord. 2 days, page number 4, my lord. Instruction. This is today's, yesterday's date, 19 June 2023.
Not made a correction
From
of the record of this.
block land reform, really Lado, my lord.
Complaint of Shekhali. It is further submitted that the record of rights
Current
pertaining
record.
to the- pertaining to the plot in question still shows the name of the collector, state of West Bengal, and the petitioner's name has not been recorded.
One application as to revise of the record of right is pending before the authorities, my lord. That has been filed by the.
Not in record. You have to come back with that application in that case. You have not annexed. Interest very good. Within 3 months from the date of order. The amount should be paid within 3 months. At Kurun, within 3 months from the date of order. It is not in dispute. Record of rights done. Respondent to submission হলো শেফালি বিশ্বাস, তারপরে এটা বললাম রেকর্ড অফ রাইটস বললাম, তারপরে কি তারপরে বলুন একটু
দাদা এটা দিন, এটা দিয়ে যেত।
Correct line add করুন, mere fact of The record of rights does not confer title in favor of the government. More so, since the civil court has declared the title and possession of the petitioner in respect of the property. Next. Hearing.
One 133.
One.
Item 133.
Hearing matters.
Other matter release.
After hearing matters, group 7 motions will be taken up.
Group 7 আছে তো আজকে।
It depends on Mr. Datta.
Datta.
Some time.
But this matter will take some time. I think my learned friends have something to say.
Regarding
time never
that
to me.
division bench order and the SLP pending, your lordship.
In this matter?
Yes, your lordship. In
My
not in this matter, your lordship. It's regarding some other matter,
Yes.
but dealing with the same points. I'm handing over the copy of the order passed by the honorable division bench.
এটা কোন অর্ডার দিচ্ছ তুমি?
Division bench is, division.
আমাদের এখানকার ডিভিশন?
Mr. Datta, I think.
No, no, no. Issues are not the same, my lord. I'll, my lord, try to, my lord, clarify the situation. My lord, in my case, which we are inviting your lordships. No, এটা চলবে না। The matter in which, my lord, your lordship's attention is being invited, these present writ petitions, my lord, this relate to, my lord, something called a rationalization scheme. What is a rationalization scheme? The scheme is that the junctions in the railway tracks, which are very busy, this rationalization scheme has been formulated for the purpose of avoiding those busy junctions. For example, if I want to go to place from place A to place C via place B, say place B is in between, which is a busy place, rationalization scheme is a scheme which is framed to avoid place B. Or in other words, the goods will be taken from A via D to place B. This is the subject matter of this petition. Now, what am I aggrieved with? I am aggrieved with certain undercharges which are being claimed from me. Why? Why am I aggrieved? I say that when I booked the consignment, you have issued railway receipts to me that the goods will be taken through a route which is 747 kilometers in length. I have paid for 747. You have taken the goods through 747 and you have delivered the goods. Subsequently, they raise bills which is challenged in this proceeding, which they call undercharges bill. Now, what is their contention? That you see, as per the rationalization scheme, these 747 kilometers would be actually 1,169 kilometers. Therefore, you pay me the balance, which they call as undercharges. My contention is twofold. Number one is, if you have transported the goods through 747, you cannot ask for more. Coupled with that, the rationalization scheme having not been applied at the time of transportation of goods, you cannot rely upon the rationalization scheme for the purpose of claiming the undercharges. This is on the facts. On the legal aspect of the matter is that under the relevant rules and the Railways Act and the rules and guidelines framed thereunder, the railways can ask for undercharges till such time the goods are in their custody. For example, from when my goods had reached to place B, they could have said that you must pay for 1169 kilometers, give me the balance, otherwise I am not going to release the goods.
My second point is, which is a argument on point of law, that you do not have any right today to go back and claim that money. Your right under the act is to detain my goods, ask for the balance. If I don't pay, you detain the goods and do whatever is permissible under law. This is what is the subject matter of the writ petition, on which, Millard, we are inviting your lordship to pass a judgment.
I'm not very sure. There's a provision that the railways can collect the undercharges from other consignments if this consignment has been released already.
Yes,
I think there's a provision in the Railways
Millard,
Act.
that is their contention, to which, Millard,
Access. So
yes, I'll deal with that. The subject matter of the writ petitions which are pending before the Honorable Supreme Court, Millard, to put it in a very, very short manner, please have a look to Millard. Millard, we have prepared a compilation of the orders of the Supreme Court. Please take only one order. অতগুলো দেখে লাভ নেই, এইটাকে বের করো। পিনাকি ঘোষের order টা। বের কর।
I think this is in substance the same issue, the rationalization scheme and the undercharges.
The Bagadi brothers, your lordship, it's exactly the same. Your lordship.
Please have a look to Millard. What is pending before the Supreme Court is, there are two things where I'll make submissions on. What is
7th January.
7 January? Well, this is an order of 7 January 2016. Please take the previous page, Millard.
Yes.
7 January. You are just showing.
Yes.
Now, Millard, when Millard, the Honorable Supreme Court, Millard was entertaining this SLPs, kindly take me to the next page. Please take the 5th line from top. The only question which is to be decided in these petitions is with regard to the charging of distance-based charge as freight. After hearing the arguments, we feel that the issue ought to be decided at a time of final hearing and not before that. Therefore, we do not intend to pass any orders. So, Millard, this is the question, Millard, which is pending before the Supreme Court, number one. Yes. Number two is, Millard, Supreme Court had stayed the proceedings which are pending before this Honorable Court. And Millard, the Supreme Court has mentioned the number of the writ petitions in respect of which, Millard, stay orders have been granted.
No dispute regarding that.
Yes. Yes. Now, please take this order dated. Yes. But after 2-3 pages of that, immediately after that order, Millard, which I placed, not immediately thereafter, but after 2 pages of that order, please have a look to Millard. 14 December 2015 order.
Yes.
Kindly take the last 2 lines. Until further orders, the further proceedings in the following cases will remain stayed.
That is not dispute.
Yes.
She never says that this case has been stayed.
Yes, number one. Number two is, Millard, when, Millard, the Union of India applied before the Supreme Court for stay of the proceedings, where the Supreme Court in the, the central government in the application before the Supreme Court had mentioned these case numbers, where, Millard, they did not deem it fit to pray before the Supreme Court that the present proceedings should also be stayed. Therefore, Millard, the railway stand was all along that except these proceedings, because there are various other proceedings throughout the country, except the proceedings, Millard, which are mentioned in this order, the next order, where the other proceedings were not required to be stayed. But otherwise, Millard, there was no fetter on the central government to apply before the Supreme Court and say that all proceedings before all high courts be stayed.
But
And our proceedings are prior to that.
the division bench judgment says that the issues are same. Please, have you,
And after that,
you have a copy of the judgment?
Millard, কোন order বলো, order date বলো?
Bagadi and others. Order.
Hmm.
January 30.
The SLP is against this judgment, isn't it?
Yes, your
Yes.
lordship.
Yes.
Lordship,
আমার দাগ মারাটা কোথায় হবে?
আর আপনার কাছে।
Okay. Yes, Millard, the division bench order of this honorable court, which my learned friend is placing reliance on, my lord will find, Millard, instead of troubling your lordship, Millard, through the entire order, Please
The
take,
submission of the appellant is sufficient.
my lord, please have a look at paragraph 41 of the judgment of Justice Tiwari.
41.
41.
Yes.
In the facts and circumstances of the above, the railway board neither could have usurped the powers of the central government by prescribing a longer route for the transport of goods under the rationalization scheme after they were booked. Even if for some reason beyond control to the respondents, such as disturbance of the railway traffic due to natural calamities, traffic being blocked due to train accidents requiring rerouting the goods for their official convenience, in that case, it was necessary for them to provide for reasons showing necessity to the consignor for such diversion under section 78, which reads so and so. There, kindly after the quoted portion, there is also no evidence on record to show that the goods were delivered by taking resort to a longer route for setting up the claim for undercharge. Even otherwise, section 78 of the Act does not provide for recalculation of freight with regard to goods carried by diverting wagons without informing the consignor. The demand for payment of undercharges, then please turn the page, paragraph 43, please take the last about 7 lines. A sentence starting with the moot question.
This is the same issue under consideration.
Yes, now kindly see, my lord. The moot question therefore is, can any further demand be raised by the railways under section 78 of the Act by recalculating the freight rate with rationalization scheme and the railway board's letter, etc. Those section 70, the rest, my lord, I will not trouble, because, my lord, these are the points which the court was considering. Then, my lord, on the merits of the judgment, paragraph 46 onwards, I will not, my lord, address you, my lord, on that aspect, whether this judgment can be relied on.
Yes.
Now kindly take, my lord, the orders which were passed by the Supreme Court in this Bagadia brothers matter. My lord, please have a look to, my lord, page number. Fourth December 2017 order, my lord, if your lordship may kindly have a look of in Bagadia matter. Yes, the first page, my lord.
Yes.
Kindly see what the Supreme Court says, my lord, in respect of Bagadia matter, 4th October 2017, delay condoned, etc., tag SLP so and so. In the meantime, there shall be a stay of contempt proceeding. Reply, if any, so and so. Therefore, my lord, what has happened in the Bagadia matters is only, my lord, stay of the contempt proceeding, nothing else. Number one. Number two, my lord, assuming for argument's sake that this can be, in my very respectful submission, this cannot be construed to be a stay of the judgment.
Not at all.
Not at all.
It's not a submission at all.
Yes. Therefore, my lord, assuming that this is a stay also, my lord, your lordships have held in the Supreme Court that the difference between a stay order and a setting aside of an order is completely different. When an order is stayed, the execution of the order is merely deferred. That is why the contempt application, contempt proceeding has been stayed. But, my lord, the declaration of law, that remains. Therefore, my lord, right or wrong, whatever is the decision of the division bench of Justice Tiwari, my lord, that is still a good law, so long the Supreme Court does not, my lord, upset that order. Therefore, my lord, as of today, my lord, I am entitled to rely on that, or my learned friend is entitled to rely on them in whose favor that order is, for inviting this honorable court to adjudicate on the present issue. Therefore, my lord, my submissions are to distinguish the two set of matters are, number one, Bagadia matter, the judgment is still a good law, number one. And number two, Rashmi Metallics matter, my lord, the stay which are operating are in respect of specific proceedings where the stays are operating. And my
dispute with regard to that.
Yes.
Only thing, when a similar issue is before the Honorable Supreme Court, let the Supreme Court decide. Let us wait till then.
Now, my lord, may I address your lordship, my lord, on what is the issue before the Supreme Court in Rashmi Metallics matter? The issue over there was, my lord, while transporting goods, my lord, the consignor has to declare that what will they do with the goods. Whether they are going to consume it in their own factory, or whether they are going to export it, or whether they are going to do some trading activities with it. Now, my lord, based on that, based on the declaration of end user, my lord, the charges differ. The allegation over there was that you have made a declaration for which you have been charged at a lesser rate. But ultimately, we have found out from your excise records and all other records that you have used it for a different purpose, and therefore a higher charge was imposable on you.
So where is this judgment?
Yes. Now, yes. This your lordship would find, my lord, from the other set of judgments that I have given to your lordship, my lord. My lord, if your lordship may kindly give it to me, I'll find out the judgment for your lordship. Yes.
Why it was tagged on, but
But Rashmi Metallics is completely on a different point.
So, well, even if we leave that aside, the other matters.
Yes, your lordship.
But this has not been stated. Well, kindly have a look.
If it's not stayed, since the SLP is pending, I would not like to deal with it now. I would like to wait.
Kindly consider, we are waiting for 2008, my lord. But I'll demonstrate before your lordship, my lord, that the stay cannot operate in.
No stay at all. Admittedly, there is no stay at all.
Yes.
Since the SLP is pending, the same issue is involved. I would wait for the Supreme Court.
My lord, my lord, may I say this, my lord? Apart from, my lord,
The decision taken by this court will be in conflict with the Supreme Court's decision otherwise.
no. Well, that's why, my lord, that's why your lordship may kindly have a look to me, the Rashmi Metallics judgment, everything would be clear.
That is different.
Different, yes.
Let us leave that aside. What are
Yes.
the other cases?
My lord, so far as my Rashmi Metallics is concerned, if it is on a different point, number one. Number two is,
Dealing
assume,
with only one of the cases, Mr. Rotto. The other cases are there, which apparently are on the same issues.
but not
The
on,
division bench judgment says so.
my lord, the division bench judgment, my lord, I mean, in the Bagadia's case, my lord, if I may distinguish by names.
In all these other cases, Skylark Fiscal Services, Anurag Agarwal, all these cases.
Your lordship, not only that,
Won't
your
it?
lordship,
Skylark.
in March 2020, similar other matters also.
No.
I just had.
My lord, tagging, my lord, does not stay the proceeding. Well, I'll give you a lordship, my lord, an example. Please take an example, my lord, hypothetically. My lord, in one matter, say, take an example. A court hears a matter and say passes an interim order of injunction. The next day we go and say that, my lord, there are 10 other similar matters. Therefore, kindly tag the 10 matters with the previous matter, first matter. The court tags this matter. Please consider, if the court merely tags the matter, can it be said that in the tagged matter also the injunction has been passed? Unless the court, while tagging, says that the injunction which has been passed in the first matter will also apply in case of the tagged matters. Similarly, over here, kindly consider, my lord, if, my lord, in respect of a issue, the Supreme Court has stayed the proceedings X, Y, and Z, and thereafter, my lord, another matter gets tagged with it. But can it lead to the conclusion that whatever was passed in the first matter or the first set of matters will get automatically, my lord, involved or, my lord, percolate into the tagged matter, which
Other matters is not very relevant also.
yes. Therefore,
Matters which are already before the Supreme Court, I'm talking about those matters only.
Yes.
Irrespective of other matters being tagged or not. That irrespective of any stay being run, here there is no stay. Admittedly, there is no stay.
There is no
But
stay.
since the same issue is under consideration, I would not like to deal with these matters.
Well,
If
this
you
is,
want the release,
my lord,
I can do that.
then, my lord, kindly permit me to come back, my lord, before your lordship, my lord, with the Chamundi Moped's judgment, plus, my lord, Justice Bhaskar Bhattacharya's judgment of our of 2007, if I recollect.
What does it say that if there's no stay, that this court can deal with it?
It says, my lord, on the other hand, that even if there is a stay, the declaration of law continues and it is not binding between the other parties.
Absolutely, but it is, I would not like to deal with this. If you want a release, I can do that.
No, kindly do not release, my lord. Release will, my lord, not benefit me.
Judicious hearing there, because I would not like to deal with the matter unless the Supreme Court deals with it.
Please consider, my lord, 2008, my lord, this proceeding. We are in 2023. Where I have taken all the trouble to, my lord,
What has happened with the Supreme Court? Is it
the Supreme Court, the matters are pending. Matters are.
2017 এর পর থেকে ওরা কোনো পার্সি কি কোনো অর্ডারই নেই ওরাও স্টের জন্য কোনো পার্সি করছে না।
There is no stay over there, my lord, kindly consider.
That's why I propose you can get a release.
Well, release will not help me, my lord.
It may.
My lord, my lord,
The other decided in your favor.
my lord, all courts are equally burdened. If I,
Mr. Datta, I don't think I can.
well, in that case, my lord, may I take a chance? May I take a chance? Kindly, my lord, fix it anytime next week. I'll bring those judgment and make a last try. Make a last try, my lord.
It's difficult, Mr. Datta, once a court decides,
Yes.
it's difficult to come out. Anyway, when you say.
No, my lord, but my lord, I have that confidence in me that, my lord, I can try to persuade the court.
Learned Counsel for the respondents submits that similar issues as in the present writ petitions are pending consideration before the Honorable Supreme Court. Paragraph, heard learned counsels for the parties. No, in reply, comma, learned counsel for the petitioners submits that pendency of the other matters before the Honorable Supreme Court shall not debar this court from hearing the present writ petitions for the reason that there is no stay order in respect of the present writ petitions and also comma. That is your principal point. There is no stay order.
There is no stay order. We have twofold submission. One is there is no stay in Bagadia. Second is Reshmi Metallics tagged matter will not, my lord.
That is immediate. That is at the immediate.
Very well.
Paragraph. Heard learned counsels for the parties. Let the matter appear under the same heading
কাকে?
on
না, ওখানে তো মামলা চলছে তো। 19 মামলা চলছে।
21st July.
I'm grateful, madam. My wife follows me on this, what you call the live stream. Yes.
You take it as a compliment.
I'm sorry?
You should take it as a compliment.
No,
Seldom
it's almost like stalking your own husband.
Next.
One 38.
For the petition I am led by Saptarshi Roy, he is unable to come to court today. Kindly make it not today.
Not today.
Let it appear on tomorrow.
139.
Same.
Not today.
Much of
Shall we go back to the motions? Yes.
In 99, my lord, both are parties are. Both in 99.
And that is have to call Dickney or ask for them.
97.
I am for the petition, my lord. Mr. Devra is for the respondent, my lord. You also make it not.
Not today.
The
state is not there, I think, in any of the matters.
99, my lord, both of us here, my lord.
Serially,
58.
only in this matter, Mr. Cornish was appearing on behalf of the added respondent. And he has requested me, my lord.
Not today?
Yes.
99.
Well, I am for the petitioner. What is the affidavit of service, my lord?
State, my lord.
Yes, state is the good way with you.
You're ready?
Well, according to that, my lord, that is not mentionable at all in that is very much point, my lord, that action is there. My lord, that
Please
we
take
are
the microphone. Please take the microphone.
Microphone.
And the state, my lord. According to that, my lord, there is so many delays. That is that vehicles are gone, my lord. The tax On the basis of the
Please
tax.
switch on the microphone, it's switched off. Please switch it on. Please switch it on. Didi, on করে দিন তো off আছে।
Oh, okay. Hello. On the basis of the tax, my lord, they are not returnable at all. There's a long times of that method are that allowed the petitioner state file an application such a point. That point is very, very difficult is to return the money. It is in West Bengal tax is there, and there is a Karnataka tax. That both the state cannot be done at all. My lord, at the last moment, that is according to the art instruction, my lord, kindly read out the entire instruction to the state.
No, no, my lord. The petitioner is the owner of the vehicle, my lord. A member of the profession, my lord. He went to Karnataka, Bangalore to his son, my lord. Thereafter he went with the car, and there he is, because the staying was longer. For that reason, he had made lifetime tax, payment of lifetime tax of the vehicle with the government of Karnataka. Now he come back to West Bengal. The government of West Bengal says you have to pay tax again here. My contention is lifetime tax has been, the word lifetime tax is enough for covering the tax payment. You cannot ask for further. Madam, I have made a representation to my legal notice, page 22. Would your lordship direct the taxing officer to consider the matter, madam, so that a recent decision may come?
This is a demand of justice.
Yes, madam.
Please make a representation.
Madam, representation is also there. Madam, if your lordship kindly come to page 17.
Representation.
Page 17. This is also madam, 8th of December 2022. Having not been concerned, the legal notice was sent.
Let this be considered by the authority.
All right, this shows the government according to the directions, my lord, it is the record.
Have you
But
given a
those
copy?
is-
Have you
yes,
given a
that-
copy?
Copy the copy the
That is,
consider করতে বলছেন তো বলতে consider করো তোমরা
that will be according to you. It is, I leave it to your lords at that point. But not properly maintained, that is.
This is not applicable here. Change of address is for permanent shifting.
my lord.
It says that when the owner of the vehicle has change address.
My lord, I am not on that.
Not a change of address.
Lifetime tax itself is, my lord, it will cover entire thing. It's a federal structure government, my lord.
If it is pending, that will be disputed.
The authority says, since the vehicle is registered in West Bengal, the
Yes.
tax has to be paid in West Bengal.
When I use the vehicle, the law is, when I use the vehicle in the particular state, I have to make payment of tax.
So let your representation be considered.
Let them consider, let them take a decent decision. So they can prefer an appeal or you can.
The instruction will set in record.
Written instructions.
Okay.
Report submitted on behalf of the respondents is taken on record. Paragraph. Contended on behalf of the petitioner that during the petitioner's visit to Karnataka with his vehicle bearing number WB16Z 0026. Which is registered in West Bengal, comma. The petitioner paid lifetime road tax. It's lifetime road tax.
Yes, yes.
Road tax.
My lifetime motor vehicles tax, your loss you.
Lifetime motor vehicles tax, Karan. Before the government of Karnataka. To the tune of rupees 34,315. Stop. Upon the petitioner approaching the respondent authorities for renewal of registration of his vehicle, which is valid up to 10th November 2023, he was informed that his road tax is due from November 2013 till date. Stop. Submission made by the petitioner to the effect that he paid lifetime tax before the government of Karnataka, Karnataka was not heeded to by the respondent authorities. Stop. The petitioner submitted a representation before the concerned authority on 8th December 2022 requesting exemption of further payment of tax, which has not been considered till date. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, upon consideration of the submission made on behalf of the parties, the petition is disposed of, directing the taxing officer, the fourth respondent, to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month
That is
from the date of
only that might instruction must be on the record that
I've
they are,
taken it already.
that is that point that there is no need
Within
necessary.
1 month from the date of communication of this order,
They are not
upon
returnable at all.
affording reasonable opportunity of hearing to the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, rejected. Next.
Asian Chakravarti. For the state.
Item 100.
State. Not today.
Hundred and one.
In this one, I'm appearing on behalf of the petitioner, but state lawyer is not here. So,
Not today.
not.
102.
I am for the petitioner. Let
Not
it be not
today. State is not.
103.
I am for the petitioner, my lord.
Both sides are not here.
Let me just call.
My lord, 103.
Not
I am for
today.
the petitioner, my lord.
State is not there. Not today. Give me just-
I want to use supplementary affidavit, my lord, for the present.
Not today,
Very well. 102.
103, my lord.
103. Jayanta. None appears for the state respondents. Paragraph on liberty of, on a prayer of the petitioner. Liberty is granted to use a supplementary affidavit in this matter.
My lord.
Let the matter appear under the same heading on, when do you want?
My lord,
14 July?
14
July?
my lord. 14 July. What does it mean?
14 July. 104.
In this matter, I'm appearing on behalf of the petitioner, but
Not
state
to-
lawyer is not here. Make it.
Not today.
In this matter, I have made an application for addition of party. Let it be appear along with.
Can one of the
Yes,
is appearing in the list?
Yeah.
105.
My application.
Not today.
No, but only one thing, that Mr. Debra is not here. Not today is all right. The lordship can allow me to file the supplementary affidavit. I have already served the copy, or I shall file it tomorrow.
Let me not give you any direction because otherwise I have to give a date.
Very good.
Let
I
us
shall,
please come back tomorrow.
I shall file it tomorrow.
106.
Not today.
107.
Not today.
The next one.
Of the board. I don't
108.
think state is there at all, isn't it?
Nobody.
Sid?
No.
শুনতে পাচ্ছ?